this the same law firm where the attorney who accused the mayor of, of not wanting access?
Okay, call to order the meeting of the Oakland Planning Board for February 12th, March 12th, I'm sorry, March 12th, 2026. Pursuant to Chapter 231, Public Law 1975, Open Public Meetings Act, duly noticed, announced, advertised, and posted in municipal buildings. The meeting will conclude by 10:30 p.m. That won't be an issue, I don't believe, this evening. No testimony taken after 10 p.m. Please rise for the flag salute.
Allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Okay, roll call, please.
Mr. DeSona?
Here.
Mr. Clark?
Here.
Mrs. Levy? Here. Mr. Marskovetra?
Here.
Mr. Connolly?
Here.
Mr. Heyman?
Here.
Councilman Talamini?
Here.
Mr. Litt?
Here.
Mayor Kamala?
Here.
Chairman Potta?
Here. Just a message for all the public that's here. We're not used to having so many people at our meetings, but please make sure your cell phones are all on silent, and try to minimize the amount of talking between all of you so we can hear everybody. At this time, I would ask our borough attorney to swear, or our planning board attorney to swear in the professionals this evening.
Raise your right hands. Do you swear the testimony about to give forward in this matter will be the truth, whole truth, and nothing but the truth?
Yes, I do.
Mr. Kimball?
As an attorney, I don't have
swear?
to take an oath. No,
I've heard
I'm obligated to tell the truth by court.
very well.
And the board engineer is, I believe, en route, so.
Yeah, I believe so as well.
Okay, so we have this evening with us our planner, our planning board planner, who's also the borough planner, Caroline Ryder. We have Mr. Brian Giblin, who's the affordable housing attorney, and we will have John Ukimic from Boswell Engineering, who will be here shortly. So at this time, I would entertain a motion to open the meeting to the public for matters not on tonight's agenda.
So moved.
Second.
All in favor?
Aye.
So if there's anybody here that wants to comment about anything that's not affordable housing, that's not, has to do with these properties that are being proposed for affordable housing, please step forward and state your name and address.
He's going to talk about historic preservation.
Hi, my name is Eric Schaubach, E-R-I-K, S-C-H-A-U-B-A-C-H. I live at 61 Loyola Place in Oakland, and I'm also the Oakland Historical Society president. As the board, the planning board knows, I've been advocating for historic preservation in Oakland. And I do have some information that might be helpful. I think that having a historic preservation element in the master plan would be useful, and also having a historic commission would be useful in this town. I'm sure everybody here is concerned about the impact that the affordable housing will have on our community. Now, historic preservation can't do anything about that directly per se, but it can help us maintain a sense of our community by preserving historic buildings and also the scale and look of the community as well. So there's a lot of opportunities. Historic preservation offers several tools that the planning board can use to help keep Oakland and guide it towards a future that is desirable for all of us. I do want to indicate that there are, to do a historic preservation element in the master plan, you'd have to do a historic site survey. And I know from Bergen County there's a grant available from the Open Space Trust Fund. And this grant would be 50-50, that the Oakland would pay up front, and then they'd be reimbursed for 50% of the fees of somebody to do of a consultant to do a historic site survey. So the letter of intent is due March 27th, and the application would be due April 24th. And as Historical Society President, I would like to avail myself as the point person on the ground on a volunteer basis to help perform this survey of historic sites as well, and also to devote resources from the Oakland Historical Society. And I encourage everybody in the town to support your planning board and support your borough council. We're all in this together. We got to stick together. And please support historic preservation in Oakland. Thank you very much.
Thank you. Eric actually has made a spiel in front of the planning board on a couple of occasions, so now that you're all here, you heard it, and also some of the council members, I believe, are here as well, so it's important for them to hear it. So, thank you very much. Thank you.
My name is Joan Check, and my address is 18 Crosby Lane in Oakland. I'm here in my capacity as the chief of the Oakland First Aid Squad to ask you, in relation to the current building, but also all buildings and all new businesses that come into town as well, that you consider the needs of the First Aid Squad and our concerns. I know the new affordable housing building that went in off of Yapo, it's 3 stories, no elevator. And for us, what that means is when we have an ambulance call, the police show up, they lug up their 50 pounds worth of gear. We show up, we lug up our 50 pounds worth of gear. And then should we need paramedics in a serious call, they come with their 50 pounds worth of gear. Then we have to figure out how we transport that patient. Somebody's got to go down and get the whatever equipment is needed for that and bring that up. And basically, yeah, it kills us. And my partner is 84. He's healthier than I am, so that's good. But a lot of us during the day, there are people who are retired and older, and there's that to consider. There's also obviously our police who help us out to consider. We don't want to hurt them. But also it's the time. If you have an affordable housing, resident, and it's going to take us longer to get them out than it would somebody in an ordinary ranch house, or, even if you have a 2-story home, you're not usually on the 2nd floor. That's just when you're asleep. Sometimes we take people from the 2nd floor, but in general, people are on the 1st floor. So we're going to be taking considerably longer. If they're heavy people, we're going to have to call the fire department and wait for them to respond to help us out. So in any case, we hope you would take that into consideration, as well as, even new buildings. Just the access for emergency personnel is something that we feel that we should be looped in on. And, I'd appreciate it if we could do that. Thank you very much.
And we will try to press some of these future developers. And we actually did on the project by Indian Hills. Former Mayor Schrader was a pitfall with them to try to get an elevator.
Yeah.
It's not required by code, not required under the affordable housing statute. So
Yeah.
Yeah. So yes.
I realize that it's something that you're limited on, but like I said, it also makes a significant disadvantage for the people who are in that housing. It's going to take longer to get them out. So great.
Thanks.
Hi, my name is Abigail Jacksarn. I live at 17 Thackeray Road. I'm here today to discuss my concerns regarding the proposed development of the McBride and Leone properties.
Okay, so that will wait. You'll have an opportunity after we go through a whole discussion here. So this is for non-agenda items. That's on the agenda.
Oh,
So we'll have
okay.
another time for opening to the public. and then we
Okay,
can-
so is that at 7 o'clock or is that,
It should be before that. yes.
Okay.
So we just have to do
so not tonight?
tonight.
Okay, okay. Okay, just not now. Okay, gotcha, okay, sorry. Okay.
Anybody else? Anybody else for non-agenda items? Okay, seeing none. Motion to close to the public? So moved. Second. All in favor? Aye. Okay. All right, so we'll move on now for our public hearing, which is the amended housing element and fair share plan, okay? And our planner, Caroline, will go into some details. She'll give us a little history. And so the reason we're all here tonight is because the planning board has the responsibility for the master plan and responsibility for the housing element and fair share plan, which is part of the master plan. So we did pass this back in June, okay, and we had challenges to the plan. In other words, there were property owners in town who raised objections to our plan, so therefore we had to engage with those property owners. I think the court hires a special master. Caroline will explain it all. And then, they have to negotiate, settlements, regarding affordable housing. So that has taken place. Now we're back here again to pass an amended housing element and fair share plan, and also to review ordinances which the mayor and council have introduced. And we just give our recommendations, and they'll vote later whether to approve them or not. So, Caroline, if you can take over from here.
Sure. Thank you, Mr. Chairman, members of the board, and everyone who's come tonight to hear what we have to say and what the board is doing. I think it might be helpful just to give a little bit of background about affordable housing in general, and why we're here tonight, and why the planning board is taking care of this tonight, and there's a council meeting immediately thereafter. Can everybody hear me?
I can, but there's somebody talking out there. Can you guys just keep it down?
What's it doing?
Thank you.
Just really quick, just make sure you're loud enough, because I know even with prior meetings, when the people watching live stream, they can't hear it on the live stream. So whether you're speaking at the podium or at the table, they can't hear through there.
Okay.
Sorry.
No.
Seats over here, if anybody wants to sit.
And I'm looking at 3 empty seats in the front row.
2 over here.
Actually 4, if these 2.
We don't buy
So, you're welcome. So, Mr. Chairman, as suggested, I think it would be helpful to go through a very brief history. If I wanted to talk about the history of affordable housing in New Jersey, it would take their full meeting. Affordable housing is what's considered a constitutional right in New Jersey. Municipalities have a responsibility to provide for their fair share of housing that is affordable to moderate and low-income households. There have been a series of lawsuits known as the Mount Laurel cases. Many of you may be familiar with affordable housing as Mount Laurel housing. That relates back to the Mount Laurel 1 and 2 cases. And I believe Mount Laurel 1 dates back to the 70s, is that correct? 75. And Mount Laurel 2, which established the Fair Housing Act and subsequently also established the Council on Affordable Housing, is from the 80s. You may be familiar with a group or an organization known as COA, the Council on Affordable Housing. And up until, let's say, 2015, that group, COA, was responsible for preparing and producing affordable housing rules, affordable housing obligations for each town. They would review towns' plans, their housing elements and fair share plans. And if they approved of the plan, they would issue something called substantive certification. That's what the approval was called. Affordable housing is handled in periods of years that are known as rounds. Right now, we are actually in the very beginning of round 4. When it was time to prepare and adopt round 3 rules, COA adopted rules that had a policy or a principle known as growth share, which was a direct linkage of job growth and population growth to affordable housing. Those growth share rules were actually overturned twice in court. After the second time that the round 3 rules were overturned, there was a third set of round 3 rules that were proposed, and the council, the actual Council on Affordable Housing, did not have enough individuals appointed to it. There was a 3-3 deadlock tie with respect to those rules, and they did not get adopted. There was subsequent litigation involving the Fair Share Housing Center, which is definitely a group we're going to be hearing more about tonight. And the affordable housing responsibilities were removed from COA and returned to the courts. Municipalities had to go through the DJ, the declaratory judgment process, and they had to come to settlement with the Fair Share Housing Center and any other interested party who at the time was known as an intervener. Oakland did participate in that process, did come to settlement with Fair Share Housing, I believe in 2021, did adopt around 3 plans subsequently and related ordinances. What happened in March of 2024, however, is that the legislature adopted new legislation on affordable housing. It was adopted by the legislature and signed into law by the governor at the time. That legislation amended the Fair Housing Act 2. I told you he was en route. Amended Fair Housing Act 2 and changed, eliminated COA altogether, and changed certain processes, and, as we're going to be discussing, established very aggressive deadlines for municipalities to meet as part of the affordable housing process. So the legislation was adopted in March of 2024. In October of 2024, DCA, the Department of Community Affairs, released what it referred to as 9 non-binding municipal affordable housing obligations. That means that it went through each town in New Jersey and calculated a, I'm using air quotes in case anyone can't see, non-binding obligation. Municipalities had to adopt a binding resolution no later than January 31st to stipulate what would their affordable housing obligation be. Would they use the obligation put forward by DCA, or would they recalculate and put forward a new obligation based on their own calculations? So there's not a lot of time between October and the end of January, because there was significant analyses that needed to be done with mapping, in particular mapping of vacant land. And I will note that although the non-binding obligations were released in October, we were not provided with the mapping until, I think, right before Thanksgiving. So we lost a whole month then. So municipalities adopted a binding resolution stipulating what their obligation would be. There is then what was established by the legislation called a challenge process. And any interested party could challenge a municipality's obligation, and those challenges were due by February 28th. So essentially less than 30 days after the last municipal obligation was so stipulated. Every municipality that did not utilize DCA's obligation was challenged by the New Jersey Builders Association. I think that was 140, 160 challenges, somewhere in there. In addition, another 68 towns were also had their obligation challenged by the Fair Share Housing Center. Pursuant to the legislation, these challenges, which were due by February 28th, all needed to be resolved by March 31st, 2025. The legislation established the Affordable Housing Dispute Program, referred to as the program, which is a series of, 7 retired judges who handled mediation and sessions on the affordable housing matters. As the chairman indicated, there would be a court-assigned expert known as a special adjudicator. They are also planners, was assigned to each case. So February 28th, the challenges came in on the obligation. They all had to be decided on by March 31st. Then,
25? That's last year.
Yes, 2025. Then municipalities, so they've finalized their obligation by March, had until June 30th to prepare, adopt, and endorse a housing element and fair share plan. So it's not a lot of time. Then, and the reason for these deadlines are very important. I'm going to take a step back for a minute. Municipalities that participated early on when there was COA and received substantive certification, or that reached settlement with Fair Share Housing Center via the court process in round 3, had what was known as immunity. And that was immunity from builders' remedy litigation, which is a buzzword maybe some of you have heard of. But basically, builders' remedy litigation happens when a municipality doesn't have immunity and protection, and it allows for a developer or property owner to come into a municipality and say, well, you haven't provided for your fair share of affordable housing, but great news, I have a piece of property for you, and it's what I want to do is not going to conform to your zoning ordinance, and it really doesn't matter, and it's going to be much more dense and of much greater scale and height than what you ever would allow. That's a builder's remedy, and that is sort of that's what everybody very much, the municipalities who are going through this process want to have the protection and that type of immunity from those situations. So failure to meet the deadline of June 30th, adoption of a housing element and fair share plan, would result in loss of immunity. That's why that date was so important. So municipalities had until June 30th. Oakland adopted its plan on June 23rd and adopted and endorsed same night, June 23rd. Then, as was established through the legislation, there was another challenge process where any interested party could challenge any municipality's plan between June 30th and August 31st. That means developers and Fair Share Housing Centers. It is my understanding Fair Share Housing Center submitted literally hundreds of challenges. Oakland received a challenge from Fair Share Housing Center as well as 3 other developers, which we'll be talking about. These challenges needed to be resolved through mediation, again, with the program and the court-appointed special adjudicator by December 31st. So it's really only a couple of months of mediation opportunities available based on the dates the challenges were due and, of course, ramping up the mediation, et cetera. So everything was settled or supposed to be settled by December 31st. And now the next deadline we're all aiming for is March 15th. March 15th, municipalities must adopt a housing element and fair share plan, which is what's on the agenda for tonight. It must be adopted by the planning board, endorsed by the governing body. In addition, all ordinances required to implement the plan must also be adopted by March 15th. Failure to do these things, failure to adopt the plan and the necessary ordinances results in a loss of immunity for the municipality. So when I say that this legislation changed the way things were done and established a series of dramatic and aggressive deadlines, it is not an exaggeration. It is the reality that Oakland and many, many other municipalities throughout the state are addressing now. To have to put together a plan only a couple months after your obligation is finally resolved, and then to have a challenge, multiple challenges that need to be resolved within a few months, and then a plan prepared 2 months later those are very, very significant tasks. I want to point out that Oakland has been very proactive with this process. Mayor, the council, this board, we have been talking about this from the get-go. I think that the legislation was adopted, March 20th or March 24th, and I believe I was here on April 9th doing a presentation on the legislation and what it meant. Similarly, we were here in January talking about the obligation and what we felt, whether or not we felt it was reasonable and what we felt could be done with it. I believe I'm fairly certain, Chairman, I also had similar discussions with the Planning Board on separate occasions. Mr. Giblin and I also attended a council meeting for an update right before Christmas, and we spoke about the challenges as well and where we were at. I will please feel free to jump in. I'm sure you'll stop me if I say something I shouldn't. The challenges, this is a litigation process. The borough is in litigation, and we do not have finalized settlements
With any of the objectors.
with any of the objectors yet. So this is a public meeting, and we might be limited with respect to what we can say or what we can answer. And that's why Brian's sitting next to me. So if I start to say something I shouldn't, I'm certain he will jump in or smack my arm. So that is the process. Oakland has been on top of this. The mayor, the administrator who is here somewhere, and everyone has very aware, and we've had ongoing, direct, and continuous communication throughout this process. This legislation, as adopted, is very, very challenging for municipalities in terms of the numbers, in terms of the obligations, in terms of the timeline. I just want to make sure that that is something that everybody understands, that while there may be frustration in this room, I have a feeling that there is frustration in this room. Please remember what started this process back in March of 2024. I just want to make sure that everybody leaves here remembering that there are various ways that affordable housing has been a constitutional obligation, has been a topic, et cetera, in New Jersey for decades. This is the first time it's been handled in this manner. This is the first time, unless you can think of other times, that we have had these type of deadlines. So I just want to make sure that is very clear to everybody. And I hope everybody remembers that as the night goes on. Okay? Okay. So that's a little bit of background. So as the chairman referenced, and as I indicated, this board adopted a housing element and fair share plan in June. The reason for the revisions tonight is because of the revisions that needed to be made in response to the challenges that were filed. Just a quick note as to why the planning board is even involved in this process is because, and the chairman touched on this as well, the planning board is responsible for adoption of the master plan and any documents that go along with it. The master plan reexamination report, which needs to be done every 10 years, any updates to the land use plan, open space plan, and there was even a gentleman here tonight speaking about a historic preservation plan. Those are all part of the master plan, which is always adopted by the planning board. The master plan can contain several sections. They are called elements. There are certain required sections. One of them is the housing element, which contains a lot of very interesting demographic information. The plan is called the housing element and fair share plan. And the fair share component is how the affordable housing obligation is being met. And again, why I'm pretty sure that everybody is here tonight. That plan is adopted as part of the master plan by the planning board. That is this board's role. Later on tonight, we're also going to be discussing some ordinances. Ordinances are adopted by the mayor and council. Those are the elected officials. Every land use ordinance has two readings. Between first and second reading, there is a referral made to the planning board. And that planning board's role with the ordinance is for what's called consistency review. That's consistency with the master plan. So that's what the board's role is here tonight. They're not voting to approve or not approve ordinances. That's the council's role at meeting number 2 for tonight. Keep going?
Going, questions from the board?
We're good? Okay. So we have the plan amendments, which I'll go through. As we stated, the board adopted its housing element and fair share plan in June. There were 4 challenges filed to the plan. Any interested party can file a challenge to the plan. The first one is the property known as, so we call it the Roper property. It's behind the property that's behind the, I used to say Oakland Pizza, but I'm dating myself. It's behind the hardware store. That is actually a round 3 site. It's in a zone now known as the RA4AH, which permits 113 units, of which 17 would be affordable. That site does not have sewer, which we're going to be talking a lot about sewers tonight as well. They came into the process and they acknowledged that they don't, that while in the sewer plan, there's no sewers available. We had multiple mediation sessions with them, and what came from that was the opportunity to potentially obtain sewer via the Oakwood Knolls pump station, which would need to be upgraded. No rezoning changes are proposed for the Roper site. The second challenge came from a property that called itself TDC, but I'm fairly certain you all know it as McBride or Hovan. That site contains approximately 66.9 acres, also no sewers, and environmental constraints, as we all know, currently within the RC and the IP zone. As part of the challenge, we had multiple mediation sessions and just sessions with the developer. They made multiple submissions with different unit counts. They did propose an on-site waste management system. Package treatment plan, is that the correct term?
That's the correct term, yes. Package
Treatment plan, which, as I understand it, means that they can take care of their wastewater themselves on their own property. Am I saying that right?
Yes.
Okay. So, therefore, the fact that they do not have sewers, they have done what we'll call the workaround of not having sewers. As I indicated, the unit count has shifted throughout the process. It is our understanding we have a settlement in principle, and there is an ordinance proposed that would permit 240 units on the property. The other,
Chairman, yeah, just for point of which, should we swear in?
We were just talking about swearing.
you're just some random person I was asking sewer questions
I
to.
was going to tell him he's considered sworn, but would you raise your right hand, John? Swear that the testimony you're about to give the board will be the truth, whole truth, and nothing but the truth?
I do.
Okay, thank you.
Thank you.
You done? Yeah. You sworn in?
Yes, I am.
Okay, sorry. The next property that filed a challenge is a property known as Leone Brothers. It is in the corporate office zone district. It is near the high school and next to what you call the Lennar property.
Correct.
Which is presently under construction today. It's a 10.5 acre site with steep slopes. And with respect to that challenge, they indicated that they believe that they could obtain sewer via an adjacent property. In response to multiple mediation sessions and other meetings with that property owner or property representative, the borough is proposing an ordinance to allow 85 total units on the site, of which 20% would be affordable. I'm going to take a step back because I'm sure some people are saying, why only 20%? That doesn't seem like a lot. We're building all these other units but only 20% are affordable. So these type of developments or even zone districts are called inclusionary developments or zone districts. What that means is they allow for typically multifamily residential that contain both market rate, what people might just call regular market rate units, and affordable units. And a percentage of the total development has to be affordable. And 20%, when you have a development or zoning like that, 20% is the maximum. It is required, and it's the maximum. It is the maximum. It used to be under round 3, you could allow 15% for rentals. That is not something we can do anymore for a variety of reasons in Oakland, but that's not something that we're doing anymore. So it's 20%. And that has the percentage that has been determined to be, anything more than that is what's, is cost prohibitive for the developer, like 25%, for example, or 30%. So I'm sure that's a question some of you might have had. The last challenge came from the Fair Share Housing Center, which challenged, I think they did hundreds of challenges, I'm not sure how many. We believe that we've resolved, what did you say it's,
They want us to resolve with all the other challenges, and then they'll settle with us.
and then they'll settle with us. That's pretty much how it works. So those were the challenges. So you want, good? Keep going? Okay.
I have questions, but.
Oh, do you want?
Well, you drafted these ordinances, right? And they're in the
Yes.
Amended housing element, fair share plan. How did these ordinances get drafted? Was there input from these developers? Was it just strictly the borough that came up with this, or was it the special master involved? How does all that take place?
It's a combination of input from the developers. In the case of, for example, the one where we had a site that was developed in the third round next door, we borrowed a lot of the zoning from that development. But yeah, the developers have, through the mediation process, the developers continued to tell us what they were looking for in an ordinance and what they would challenge if we're not in an ordinance, or if something was in the ordinance that was, in their opinion, cost generative, that they would challenge that. So it's been a negotiating process throughout.
And you had mentioned that we're not totally settled with the objectors. So are they not totally on board with the ordinances 100%, the way we have them written?
They are
right
not.
now?
The developers are not satisfied with the ordinances.
more. They
Yes,
want- okay.
that's exactly right.
Okay. Thank you.
In fact, not in Oakland's situation, but in other situations, if we have a concept plan that is more finalized, the ordinance often is developed to reflect the concept plan in this affordable housing arena situation with a challenger. That is not an uncommon, that practice happens. So yes, the developer or the challenger or the challenger is often involved. These ordinances will also be subject to review by the Fair Share Housing Center and by the adjudicator as well, the
Correct.
special adjudicator. You referred to as a special master, it's the same thing.
And ultimately by the Superior Court, which
Superior
has to
Court.
approve our plan.
So right now, if we pass these items tonight and the mayor and council do their thing and pass, we're protected from the builder's remedy, but we're still not quite there,
Yes.
because there's still.
We've met the
more.
deadline, the March 15th deadline, to introduce zoning that makes a realistic opportunity for these developments. But we're not through the process yet. We still have to get, we're in front of Judge Lena Carsten. We've already had our first case management conference with her earlier this week, and she's looking for us to have settlements, signed settlements with these objectors or she's going to decide whether or not what we propose or what we ultimately come to terms with is sufficient.
And much of this negotiation has been like last minute with us, right? I mean, it's, a lot of it has been, you know, you think you're okay and then,
Well, without saying who it was, one of the plans was changed literally as I was driving here when you introduced the ordinances 2 weeks ago. They asked us to change, we didn't, but they asked us to change the ordinance the day it was being introduced.
so.
Mr. Chairman.
It's difficult.
Could our professionals expand on the fact that this is just an ordinance change and talk a little bit about how this still, if this were to happen, that there's still a whole planning board process and everything else. Could you just kind of split that up a little bit?
That's a great comment. Thank you for the reminder, Mayor. So that's what is being done tonight is hopefully adoption of the housing element and then adoption of the ordinances. The ordinances are adopted tonight as they should be. There is not going to be anybody out there with hammers and nails tomorrow. There is still a public, in addition to all the review and the Judge Corsten and everything else that needs to happen, within this process, there are public processes. So there would be what is known as a site plan application, which is pursuant to the New Jersey Municipal Land Use Law that this board handles, review of any type of new building. It would be a public meeting, it would be required notice, and it would be held with the public could attend and comment as needed and as we're interested. And I'm assuming that for some of these, there would probably be multiple public meetings. When you heard the Lennar application, did you have more than one meeting?
It took a period of 2 years, approximately, to
Took 2
approve that.
years. So that's the same process, so that everybody knows.
And may I add, Mr. Chairman, that also third-party permits, especially sewers,
Yes,
and
DEP.
any environmental constraints on the properties, that they are obligated to obtain those permits from the DEP. And sewers, they would have to do normal water allocation permitting on certain sites, and that is a process as well. And it could be a costly process for the developer. We don't know that yet.
That's another great point, is that it's not just the planning board approval, it's any type of NJDEP approval that is needed, whatever is needed with respect to the sewers, even the Roper site, which is not, there's no rezoning proposed, there would be a sewer upgrade needed of the Oakwood Knolls. So that, that's a process as well. There are multiple, this is a multi-step process. That's a great comment. Thank you both.
Okay.
Ready? So just for an idea, DCA, as I indicated, DCA issued what was referred to as non-binding obligations. The non-binding obligation for the Borough of Oakland was 300, for round 4, was 306 units. We worked with the borough to calculate an alternative obligation that was 252 units. There was an objection from the Builders Association. We went through process mediation, worked with the special adjudicator, and the end result was an obligation of 286 units, which was a significant decrease in obligation, although it doesn't sound like it compared to a lot of other towns. So that was the round 4 obligation. Every round has its own obligation. Every obligation is cumulative. Excuse me, the obligations are all cumulative for your affordable housing obligation. The official term is prospective need, but it's basically the affordable housing obligation. So you have a round 1 and 2 obligation known as prior round. You have a round 3 obligation and a round 4 obligation. And if everything continues the way it is in the legislation, in 2035, you're going to have a round 5 obligation. And in 45, you're going to have around 6. You'll see where this is going. This is continuing. I'm going to give you the numbers, but I think we're just going to talk about the round 4 obligation tonight. The numbers prior round obligation, rounds 1 and 2, was 220 units. Your round 3 obligation was 462 units. Your round 4 obligation was 286 units. So
None of them
No,
were built.
and they never will be. I believe we have one that was built.
So
Plus the 40.
You have 40 in Lennar.
for you have the Lennar, you have the Lennar site, which that's under construction.
Yeah, but that's 40 units.
Right. So you have so you don't, as everybody knows here, I'm sure you don't have sewers, right? So there is a process when there is something within this process known as a durational adjustment, which is a deferral for municipalities, a deferral of an obligation for municipalities that don't have infrastructure, either water or sewer, or both for some municipalities that may be in that situation. So I'm happy. So,
You'll have an opportunity.
Mr. Chairman, I'm happy to keep going, but I will say that the background noise gets just
Yes, please, everybody.
so you have. Sorry, I just lost my place. The deferred, the durational adjustment. I did the numbers, the durational adjustment. You also have a 10-unit rehabilitation obligation, which you meet through the rehabilitation program, which is not really worthwhile talking about much more than that. Just dealing with the round 4 prospective need, we have the durational adjustment. However, we had the 2 challengers that came forward. We had three developer challengers that came forward. One was a round 3 site, so we don't need to speak about that one anymore in my mind. The other 2 are the round 4 durational adjustment challengers, Leone and McBride. So those 2 properties are within the plan, provided they're able to somehow obtain either sewer services through an adjacent property owner or on-site via the package treatment plant, package treatment. So those are the 2 properties that are within the plan. I'll go through them again. The borough is proposing for rezoning of the 2 sites. The McBride site, allowing McBride, Hovan, TDC, however you want to phrase it, 66.9 acres. We note that the challenger claims that 27.5 acres are developable. Our analysis, which is not based on anything official other than DEP information, indicates that it's less than that. Obviously, any formal application to the board would have all fully engineered plans, DEP analyses, things like that. So that would be resolved as the process, should the process go forward. And this time, the borough is proposing rezoning of that site to allow a maximum of 240 units, of which 20% would be affordable. The developer challenger has indicated it would provide its own on-site wastewater treatment plant, package treatment plant. The other property is Leone Brothers, 10.5 acres, has steep slopes, and the borough is proposing rezoning of 80 to permit a maximum of 85 units, of which 20 would be affordable. Neither has provided a final concept plan, correct? We still don't have final concept plans for either to reflect the numbers that I have just told you. We have a variety of concept plans from both of them. Finally, in addition, the borough rezoned an area of what used to be called its Central Business District, CBD. It's now called DT Downtown 1, I believe, and we're, as part of this process, proposing a slight density increase in that location as well. That's the Copper Tree Mall area along Ramapo Valley and areas along Ramapo Valley Road. Of course, those nothing can be built there without sewers either, but it's just a slight rezoning there of an increase in density from 18 to 22 units an acre. That is really the meat and potatoes of the plan. Was there anything you feel I missed, Mr. Chairman, or?
Just maybe a little procedure. So, you're discussing the plan. We also have to go through each of these ordinances, which you did. You just gave us a little brief but we may have to go through those in a little more detail when we actually discuss those.
Yes,
And
yes, I don't disagree.
yeah, so my plan was now is, once you finish with everything, is to have the board ask any questions, and then I'll open to the public and have the public, grill us with whatever questions they have. And maybe we all need to understand those ordinances a little bit, like some of the details, some of the gory details of those ordinances.
Do you want me to go through them now?
I think so, yeah. I think I'd rather you go through all that.
Yeah.
And
Which
then,
ones were referred to, which ones were referred to the All right, we'll go through the appendices in the plan that contain the ordinance. Is that what you're asking me?
Sure.
Sure.
Chairman,
Okay,
I want to tell people they can move down here.
no problem.
Three seats over here.
Yeah.
There's some more seats in.
So there is some room, if people want to come in, there's some room over on this side, rather than put them all up there. There's a few seats scattered around if anybody wants to sit.
So Appendix A actually is your rehabilitation manual. It's not an ordinance. Appendix B is the new affordable housing ordinance, including a development fee and mandatory set-aside ordinance. This is like a 40-page document based on a state template prepared by New Jersey DCA, which was released on February 13th. It's every town that's participating in this process needs to adopt new, just the general affordable housing and development fee rules, because the state also issued new rules on those particular, on certain aspects. Those were only, the new rules were released in December, so every municipality, like I said, has to update their affordable housing ordinance, their development fee ordinance accordingly. We followed the state template, which has since been removed from the DCA website. However, it's being encouraged that municipalities move forward and adopt this ordinance and amend as needed upon review by Fair Share Housing Center.
December of what year?
December of 2025.
Just so I want people to understand how fast this is moving.
So what happened in December 15th of 2025 is there are rules. They are known as UHAC, which stands for Uniform Housing Affordability Control. They very much regulate affordable housing units, size, location throughout developments, bedroom distribution. If you've ever attended a meeting where there's affordable units being discussed, someone like me will say something like, well, you have to have, 20% three-bedroom affordable units and 30% two-bedroom affordable units. That's the UHAC rules. New UHAC rules require integration throughout the development. For example, I believe Lennar has a separate affordable housing building that is no longer permitted. Affordable units per UHAC need to be not only integrated, but the same. They need to be integrated throughout the development. They cannot be clustered in one location or in one particular part of the development, in particular that might be seen as a lesser part of the development, and they need to be of the same unit type. In other words, if you have a townhouse building, you need to have both market and affordable townhouses in that building. If you have a stacked townhouse building, which would be one unit on top of the other, you have to have both market and affordable stacked townhouses in that building. Those new rules, new UHAC rules were adopted. I think they were published in the Register December 15th, 2025. In addition, the development fee rules, which are fees that are paid by for new homes, residential developments that do not include an affordable units, and new non-residential development pays something called a development fee. That money is deposited into a separate interest-bearing account known as the Affordable Housing Trust Fund. Municipalities that have development fees and have the account have to follow certain rules. Those rules are collectively known as 599. Those rules also were adopted in December of 2025. This state template, this template was put out, like I indicated, by the DCA, Department of Community Affairs, on February 13th, which really gave everyone plenty of time to review and prepare the draft ordinance, which had to be introduced just a couple weeks later. Of course, and now, as I indicated, it is my understanding that DCA has removed the template from its website, but municipalities are still encouraged to adopt the ordinance, even though DCA may be making some changes and there may be amendments required in the future. However, because we have the March 15th deadline that state will not give an extension for, municipalities need to move forward with that ordinance. And that's the Appendix B, and I think, like I said, it's about 40 pages. Appendix C is the ordinance for TDC, which many of you know as McBride or Hovan, that creates a new affordable housing zone for this property. It allows for the construction of 240 residential units with 20% set aside. The 20% would be affordable units. Permits stacked townhouses, and flats, which multifamily, with certain limitations. Also allows accessory type structures. Minimum tract area 50 acres. There's setbacks, etc. Building height, depending upon the type of development that it is, if it's townhouse or flat. There are some local ordinances that are not applicable to this due to
They're being cost generative.
the developer. The developer requested it. The ordinance also stipulates that the development shall be designed so that only emergency vehicular access is permitted from Page Drive. I don't know if anyone wants to, Mayor, did you want to?
Well, I just want to point out to the board members that two of our ordinances, the steep slope ordinance and the tree removal ordinance are not applicable to that development,
That's correct.
based on the fact that their costs.
Courts have found that to be cost generative, which is not permitted when it's an inclusionary development. That's specifically prohibited by the rules adopted by the state.
They get to break the rules.
And we could their rules. Yeah, break the rules.
Okay, you'll all have a chance to comment.
Will that be soon? Because I have childcare that I need to leave. If I can leave when I wrote.
If you're gonna pass the ordinance, it's just
I'm sorry, I can't
Yeah,
hear.
it should be soon. We're getting close.
So the ordinance, you want to talk about, maybe talk about Page Drive, but that's not what they shoot from this.
No, I would just go to the next one.
The next one, Appendix D is the ordinance for the Leone property on McCoy Road. That permits 85 units maximum, not less than 17 or 20% would be affordable. Permitting stacked townhouses and traditional townhouses. Much of this was based on the adjacent Lennar ordinance. That's Leone. Appendix E has to do with the DT1 zone, which is an increase in density, and also clarification that the set aside is the affordable set aside is 20%. Resolutions. Appendix G is sewer expansion timeline prepared by Boswell Engineering, and also a traffic study of the Hovan, which is also McBride. They were prepared, these documents were prepared as part of the process of mediation and provided to the special adjudicator. There are other ordinances that aren't part of this. The DT2.
Yeah.
The other ordinance that's not an appendix is the DT2, which is a smaller downtown area. That is the only thing in that ordinance that's changing. It's not even necessarily changing, it's clarification that the set aside is the affordable housing set aside is 20%. There's no other changes proposed with respect to DT2.
Okay.
That's the ordinances.
Okay, all right. Board members, questions? Raise your hand if you have questions. Joe, go ahead.
Calvin, with the 20%, that's the,
Can't hear you.
I can't hear
speak
you.
up, please.
Is your mic on?
The 20%, that's the maximum we can enforce, or the minimum the builder has to do.
Yeah, we
Depending
can't
on your
require more than 20, that's correct. We can't require more than 20%.
That's the maximum we can enforce.
That's the maximum we can
And
do, that's
a
correct.
builder could, on their own, do more than 20 if they choose to, but there's zero incentive for them to do that, correct?
Zero incentive, I haven't had much experience with such an offer.
And then one other question is, if we fail and lose our
Immunity?
Could these 3 properties, in theory, come and do the same exact thing with like double the units?
I was gonna say, they won't do the same thing because they're gonna come
No.
back in
But they could come
and do, yes.
the same exact thing with like double the units, and we couldn't stop them.
Yes, well
Okay.
then, there would be court case, yes, you'd go, yes.
Thank you.
Yes, double the units. They would not come in with what you're seeing here would not be,
They're compromised.
right. And not just these properties, by the way. It's not just limited to these properties. It would be any property that was able to prove it could have some opportunity either for sewer, or even maybe not necessarily, could come forward and indicate that they have, they have the solution to the situation, and you don't have protection. That's why that's why this March 15th deadline, and that's why I keep harping about these aggressive deadlines, because failure to meet a deadline such as June of last year, or March 15th, Sunday, next, however many days, 4 days away. Failure to meet those deadlines results in a town potentially losing its immunity. Yet the deadlines are aggressive and unrealistic, resulting in, every town is doing some sort of special meeting, be it planning board, council, or both. You can't otherwise get everything done you need to.
Just to follow up on that, the other thing that happens is if a developer or a property owner is successful in a builder's remedy lawsuit, the municipality will wind up paying all of their attorney's fees and expert fees as well. And towns have paid literally millions of dollars and gotten much more development than they wanted because of those types of cases. So we'd like to avoid that.
And when that's all done, then they have to come back and adopt a housing element and fair share plan. So it doesn't absolve you of this whole process. That's part of your settlement with the builder's remedy, is then preparation of and adoption of the plan, like what we're talking about tonight.
Mr. Conlon?
I just want to make a statement. Everyone here is very passionate. This board, and I'm sure the council board, we all think it sucks, quite honestly. I'm probably not allowed to say that word on TV, but when you look at Oakland, we have an obligation of 968 units, unrealistic. 4, we have an obligation of 286. Right now, with these 3 sites, it's only going to build out 82 units. If we do not adopt these tonight, these builders will come in and take the McBride site and build 450 units. Or more, and we'll have no control over what they do. And again, I'm passionate about, do I want them? No. No one on this board wants them. And I know no one out in the audience wants it, but our hands are tied behind our backs here. And I have an obligation. You'll have your time. I have an obligation sitting in this board to protect the residents of Oakland.
It happens all the time with deadlines. Every time I'm at a meeting, there's always a deadline. And it's always a few days before a deadline.
And respectfully,
you'll have
these
an
deadlines are
opportunity.
established by the legislature. These aren't my deadlines. I'm trying to make sure that everyone's aware. We're all trying to make sure, because Oakland takes this seriously, we need to make sure that everybody's aware of the deadlines. That's what we're doing. These aren't Caroline deadlines. I didn't just wake up and think these,
And so do we all. But we're coming in, there's people that are here now. we need to extend these deadlines, so we collaboratively
So
do something.
I'm with you. I wish, but the state won't extend the deadlines.
Maybe somebody here needs to go to the state.
If you would like to give us immunity and put up a couple $1 million, I'll take your offer right now. But no, and I'm being serious. No, I just need silence.
No, I think we have to
Yeah,
get
could we
control here.
Yeah.
try to keep things under control here?
Yeah.
Everybody
And-
will have a chance to talk.
Yeah, and again, we're all in it. We're all in it together. I'm here to protect Oakland, as every board member here is, and the council, and we're going to do what we have to do to protect the borough of Oakland. I will vote that way. And I thank Caroline for taking the heat. Thank you, Caroline. I think it was a very good presentation. Thank you.
My pleasure.
Okay, other questions, comments from the board before we open to public?
I guess one
Go ahead.
common question. Eventually, the downtown development would satisfy a lot of affordable housing requirements, right? And that's
Yes.
where we got the durational extension, or we can defer things, we don't have sewers, but the developing the downtown, once sewers in place, would address a lot of our
Absolutely.
affordable housing,
you have,
right?
You have a lot of other things in your Round 3 plan that would address it as well, but none of these things can move forward without sewers.
Sewers, mhm.
So that's why these two developments, I think, this is what distinguishes them a little bit, is what I believe happened, is one is doing it's taking care of its wastewater on site, and the other one is indicated it will go through an adjacent property. So it's a little different, right, than, I'm sorry, it's so hard to hear when there's noise,
Yeah,
people.
please. Anybody else? Okay, motion to open to the public for comments.
Second.
All in favor?
Aye.
Okay, one by one, and try to limit your comments, please, to 3 minutes. I don't have a timer, but we just want to make sure
I have
everybody.
it written, so I'll go as fast as I can.
Thank you. Name
Again,
and address.
Abigail Jacksarn. I live at 17 Thackeray Road.
Come on, quiet.
I'm here today to express my concerns regarding the proposed development of the McBride and Leon properties. As a resident of Oakland for 23 years, I have always valued our town's character as a peaceful tree-lined community nestled in the Ramapo Mountains. However, recent increases in development and businesses have raised legitimate concerns about Oakland losing its distinctive identity. While I recognize that many decisions are driven by state requirements, including compliance with the Mount Laurel Housing Act, it is important that we do not compromise the integrity of our town in the process. The ongoing construction adjacent to the Indian Hill School has already triggered significant community concern, particularly due to its impact on local traffic and public safety. The anticipated rise in traffic from the proposed development will further strain our already congested streets. In light of recent tragic events involving child safety, it is crucial that this remains a top priority. Our schools, which are currently over or at capacity, would require rezoning to accommodate additional students. Specifically, the McBride property development would likely exacerbate cut-through traffic on Walnut, which my parents live on, and I'm here on their behalf tonight, Dogwood, and Grove Street. I understand the necessity of fulfilling state obligations to avoid penalties, but we also have to uphold our responsibility to safeguard our community. Although various stipulations have been discussed regarding the McBride property, the potential negative consequences of such a development, including increased taxes and demands on our police force, are substantial. There is an upcoming project at the old Burger King site, which would likely contribute further traffic to congestion in an already busy area. As an alternative, I suggest the council consider engaging with owners of vacant buildings within our industrial park, where repurposing existing sites would meet state mandates while preserving our town's natural beauty. Surrounding communities such as Franklin Lakes have successfully utilized commercial properties for their affordable housing requirements, demonstrating that there are viable alternatives to new development. Additionally, the proposed McBride development site includes a stream and sensitive environmental areas, and Oakland already experiences frequent flooding. Further construction may increase these risks. I thank you very much for your time and your consideration. I appreciate the efforts that are being made by our Oakland board here to comply with state regulations, and I just continue to urge you guys to protect our unique character and our environment. Thank you so much.
Thank you.
the next person speaks, Caroline, if you could, I know a lot of people will have the same, and they're valid concerns, the school system and traffic, okay? Now, obviously, these developments are going to increase demands on both of those. What's our position on that, or how can we, or what if we decide that we're not going to vote for this because our schools can't handle the capacity?
Because your school is bursting at the seams, right?
Yes.
That's what, so I've been hearing that a lot, that the schools are bursting at the seams, and the answer, unfortunately, is always the same, is that that is not a reason to not move forward with an affordable housing project or plan in terms of the Mount Laurel Doctrine. Similarly, concerns about roadway, traffic, police force, ambulance services, et cetera. Those type of reasons are not valid reasons to move forward. Those are not valid reasons to not move forward with this. So I'm sorry.
In other words,
this gentleman should come.
In other words, those are our problems to solve.
Exactly.
We have to provide the affordable housing. If we need to build another school, we need to add on to a school, we need to widen the road,
It is my understanding that boards of education prepare long-range plans looking at future development. I know because often they contact us asking about, developments in the pipeline, but that's a board of education function. You also have a regional school, so I'm certain that the other municipalities that lead into your schools, I'm sure, fairly certain they're going through the same thing.
Yes.
Can I just ask a clarification that they brought up? Two questions I don't understand.
Could you
talk about
state your name and address? Stand up at the podium.
A quick question.
Yeah.
You talked about two key issues, sewers and water.
Name and address.
Oh, I'm sorry. Chris McKinney, 60 Grove Street.
Thank you.
Talk about sewers and water. I'm having a hard time. First of all, I don't understand how our water in Oakland is going to change. Are we getting more water? Where's this water going to come from? So if you could make clarifications how we're going to address that. And second of all, explain the sewer system. You're using a technical term. It's a closed blah, blah. What is it? What does it do? How does it work? Who's going to take care of it? When it breaks, who's responsible? And where's it going to go? Does it just disappear in the air, or
I think that the engineer would.
Exactly, but they're key issues you're talking about.
I agree.
Yet, please enlighten us. Thank you.
You're up, John.
May I, Mr. Chairman?
Yes, please.
Yes, so it is the developer's responsibility to satisfy the supply of water for his or her development and to get rid of wastes. That is clearly the developer's responsibility. That is not a cost-generative item as far as I'm concerned. So obviously to live there, you have to provide these things. So the developers have not yet proven to us that they have adequate water for these sites, and they might not be able to prove that there's adequate water supply for these sites. We have not gotten that far yet. And if there is not adequate water, they would have to build the infrastructure at their cost to supply the water for these sites.
Excuse me.
So,
how do they build? Where do they get this water from?
well, it's a process. You need permitting from the DEP. They have to, one scenario would be to build transmission lines from Veolia from Franklin Lakes. So these are all costs borne by the developer. So in answer to your question with regard to what this sanitary sewer package plant is, it is basically a sewer treatment plant that is on site, that is owned and operated by the developer and eventually by the homeowners association. And they would be responsible and at their cost to dispose of the waste. The Ramapo River Reserve has a package plant that currently now services 400 families on the other side of the Ramapo River. So that operates, and that is totally maintained, and the cost of that is by the homeowners association. So it's a small sewage treatment plant is what it is. I hope I answered your question.
And another example of where a new development in Oakland by Indian Hills, they're getting their water from Franklin Lakes, they're sending their sewage to Franklin Lakes. So there's ways to work it out. Oakland couldn't provide that for them, but Franklin Lakes could provide it, so. Yeah, and again, we're not in the details yet of any developments. There's so much more to come, if these properties are going to be developed. There's a whole site plan application. There's all kinds of approvals that they need. And John just touched on a few of them. The water, where's the water?
I don't want to sound hopeful, but I'm going to say this. Our experience has been, being the town engineers in many other municipalities in northern Bergen County, is that you hear about all these units, and what typically, I want to use the word typically. I'll just say we've been seeing that developments that do make it have much less units because it's not able to pencil out for the developer with all of this infrastructure that they have to build. One case in particular, everybody in this room probably heard of Bi-County. That was a buzzword a couple of decades ago here. That probably will never pencil out for the developer because of the amount of infrastructure that developer would have to build for that site. So I don't want to sound hopeful, but there is a good potential that these sites might not be the magnitude that we're zoning for this evening.
Mr. Chairman, just a question for Mr. Kemick. There's a lot of new faces here that have not lived in Oakland. Could you just give a reference to where the Bi-County property is?
The Bi-County property is along the Wayne border, off of Breakneck Road and further off of Long Hill Road. Thank you very much. I was getting there. I'm old. Thank you, Mayor.
Hi, I'm Dr. Irene Burke. I've lived in town for 28 years. This is going to be very short. I was just stunned by the numbers that I just did of the 968, because by my calculations, that means 4,840 units would have to be built in Oakland. Currently, we have about 5,000 homes, so double the homes. So when we talk about water, we're not talking about, that someone's got to pay a water bill. We have well water. Well water runs out. Okay, you look at Kinnelon. Kinnelon is having a desperate problem right now because they don't have enough water for the buildings that they have. Okay, fortunately, they have some way to get around this building anymore because they have some protected lands there. The infrastructure cannot be overlooked. Okay, the roadways. Some towns say we can. Maybe you can. We have 4 lights in town. We have 1 main road. That is it. Okay? We have 5 schools. That's a lot. All right? I don't know if everybody's aware of the number of very bad accidents that happened at the intersection of Page and Yorpo this year. All right? Because of I think the timing of the school may have contributed to that. Page is an extremely difficult and very dangerous road. For people that don't live on that side of the town, as I do at 5 Hannah, Page is a double yellow line. It's supposed to be 25 miles an hour. It's rarely anything less than 50. All right, there are no sidewalks. I walk my dog. The road has been recently riddled by the utility companies with pothole patches. Mother's Day 2024, walking my dog, I tripped over one of those. I broke my collarbone. All right, I'm a fairly physically fit person. I don't believe that they're not going to come through Page. I don't know where. Do we know where they're coming through? They want to come through. They propose. Someone does? Anybody does?
Nothing's approved.
Okay. They're talking about their wastewater, that they're going to take care of this effluent wastewater, and it's going to drain somewhere. Yes, it won't have bacteria in it, but it'll have chemistry in it. Chemistry from people's medications, chemistry from cleaning. Yes, the Ramapo Reserve also has its own that empties into the Ramapo River. If we build 4,840 units and start dumping that water into the Rampo Reserve, which is supposed to be somehow protected, I'm saying to the board, instead of saying that we won't meet obligations, pass these silly ordinances tonight, just so you don't get in trouble on the 15th. Keep your immunity. And then start going after things like saying, Oakland is not a regular Bergen County town. We don't have water, we don't have sewers, true. But we also have environmental concerns that are going to be absolutely destroyed if this comes in like this. These 968 units, builders don't want to build it because they want to make profit. They want profit. So maybe we can look for builders to say, hey, listen, come build these 948 units for us, not 4,840. And the town will subsidize, or maybe we sue the state to subsidize. You know, there's got to be a different way of thinking around the back end, not just going, I know they're just throwing all these unrealistic numbers at you, and you're trying to make these things go, and I understand that. I mean, you guys could be working all weekend. But we have to stop thinking the way they want us to think and come around the back door and say why we can't have this, and it will destroy the... If you go and look on Page, there's 2 more houses today up for sale. Houses are going to start popping up for sale when they start seeing this. And it's not because I don't want a 3-story building. I don't run out of water. Not to mention the fact this is my first year after all these years. I've had every night 2 to 3 dozen deer in my backyard. This year, my deck and 2 other neighbors, the deer was sleeping under our decks. They have nowhere to live. They have nowhere to live. So if you get the McBride property, less McDonald's took away. The high school took away. Anyhow, that's my point. I have to sit down.
Thank you.
Good evening. John Skirbo, 77 Spear Street. I am the president of the K through 8 school district. I've actually had the pleasure and honor to serve on that for 21 years now. I've made it perfectly clear in the past, and I'll state it again. Allowing these types of projects will have a terrible impact on our school district. My board has informed me to come here and speak to you tonight because they have major concerns as well. You can make a comment that we have long-range plans, and that's absolutely correct. We always have. We even have long-range plans financially, and that's why our district is solid and doesn't have the issues that exist in other towns where they're laying people off in the near future because they've managed their money improperly. The fact of the matter is we're very successful. People move here for our schools. We are at capacity and above. When you sprung on us, and let me just say this, the mayor and council have been tremendous in sharing information and our partnership. I am very pleased with where we are. The fact of the matter is last time we were sprung on a project, very last minute with the high school, which had major impact on the school district, where we had to lay out $10,000 for a demographic study out of pocket, which we didn't have in our budget. We actually had to make an arrangement with OLPH for $300,000 a year at least for 5 years to make sure that we have the availability and the space for our children to grow and learn. And now we're having these projects look forward that are going to have a major impact on us as well. We've converted locker rooms to small class instruction. We've converted storage rooms to small class instruction to accommodate our children in every aspect that they need. The fact of the matter is that's cost us several $100,000. And if you believe that these projects are going to come in and these students are going to arrive in our district, we're going to have to go forward for a referendum. Now, we looked at a referendum that cost $25 million when we were sprung on this last project to build onto our existing buildings, all of them. The board decided that there was no way we're going to bring that to the community and have that financial impact on them on the taxes. But going forward, if these projects come in, I will guarantee you we will have to look at every option available to accommodate these children. Because right now we are full in our buildings, and you add any more to what we have, we got a major problem. And the fact is that we have to look at every option available to us, and ultimately the community and this town and these taxpayers will have to suffer the consequences of that. But the fact is also that because this school district is so successful and has a great reputation, people move here for that reason. And the values of their homes in this community are affected greatly by that fact. The only other option that people have is to look elsewhere, and to be honest with you, this is the community to be in. So I would ask you to consider that going forward in all these projects that are being brought up to you. Because where is the money going to come from for the schools? We don't have it. Our budget is tight as it can be. And the fact of the matter is, our buildings are as well. So I'm going to ask you to please keep that in mind going forward. I continue to ask you for the cooperation, partnership, and the continuing of sharing information as you have. But the fact is that right now, we have a major problem on our hands if these projects go through, because you know for a fact that these children will be coming into our district, and we have an obligation to serve them in every possible way to make sure they get the best education possible. Thank you.
I just have a brief statement, then I just have a question for the planning board. Good evening. My name is James Backlauer. I live at 170 Page Drive. I'm the one that posted some of this on Oakland Neighbors, and thank you all for saying sorry for what's about to happen to my property. I want to thank the mayor, the borough administrator, and the borough attorney for meeting with me and several of our neighbors. Again, we're in the crosshairs of this last week. It was very helpful during what's been a very difficult and concerning situation for our neighborhood. Well, I've only lived in Oakland for less than 2 years with my wife, Meryl, and our 2 young daughters. My family's connection to this town goes back decades. My grandparents, Robert and Frances Hunt, lived at 84 Walnut Street for almost 60 years, and I spent much of my childhood here in the Dogwood section. After nearly 3 years of searching for a home in what's been a horrible market and a very difficult time, my wife and I were fortunate to find our house at the quiet dead end of Page Drive, next to what the borough has previously described as the undevelopable McBride property, also known as the Sand Pit. It's a peaceful area filled with young families, children playing outside, neighbors walking throughout the day. In its current form, the location of our neighborhood is an A+. The neighbors are even better. Receiving a recent notice about the proposed development of the sand pits was deeply concerning. After finding the preliminary plans, it appears that Judith Lane, currently just a small access drive for myself and my neighbor Sandy, could become one of the main entrances to a townhouse development. The plan also suggests excavating the steep wooded hill, which is so steep I can't even walk my dog up there because she'll fall. She's tiny. The plan beside my property and building townhomes along our property lines, essentially surrounding my neighbor's house with townhomes. What I thought was a dream looks like I just introduced my children and my wife into a nightmare. This would dramatically change our neighborhood and our property values. Grove Street already experiences traffic from drivers cutting through to avoid Ramapo Valley Road, adding another cut through from the business part to Page Drive would significantly increase traffic in an area where children play and pedestrians walk daily. Oakland already tragically understands the dangers that excessive traffic can bring to our residential neighborhoods. In saying that, I'd like to thank the town for understanding this, at least putting in the ordinance that Page Drive can only be used for emergency access to this proposal so far. I expect the town will continue to do what's right for our neighborhood and stand firm on that issue to the end. I want to be clear, from what I've seen in this development, it's unacceptable. The proximity to our homes, the use of Judith Lane, essentially my front yard, as an entrance shows an absolute disregard for the privacy, safety, and character of our neighborhood. We pay a premium to live in a neighborhood where we can enjoy our privacy and walk the roadway without fear. We should never be asked to compromise on these important quality of life issues. Over the past week, I've spoken to many neighbors who share serious concerns about traffic safety, environmental impact, the impact on our privacy, and a long-term impact on our community. I look forward to working with these neighbors through this project and the council to address these issues. Again, my expectation is the Borough of Oakland will do everything in its power to protect our neighborhood from this irresponsible planning and the overdevelopment that threatens the safety, character, and quality of life of our community. And thank you for your attention to this matter. I do just have one question, especially as it pertains to Page Drive. As of right now, Judith Lane can barely fit the garbage truck down it. My daughter laughs hysterically and watches it every morning. Would the town utilize eminent domain or the easement area to facilitate the use of Judith Lane in any capacity? Has that been discussed or in any plan?
Has not been discussed. It's not in any plan. We haven't gotten into any kind of detail like that.
Is that
But
something?
as you said, we do have it in our ordinance to exclude that access.
Okay.
Yeah.
My understanding is the developer was pretty steadfast on making that a main entrance. Is that something the town
He
will?
wants that as an entrance.
Okay. But my question is, understanding these concerns, I know Ryerson has an emergency access point there with just the gate. They recently moved more rocks over there to prevent people from going around it. I walk down there almost every day. We understand what's going to happen if that opens up from the business park to people from Wayne, and now 250 townhomes of what that whole area is going to turn into. So again, my expectation is that's a fight that's worth having to the end. That's not something that
I
we can
think the
just...
borough intends to fight
Okay.
that.
Mr. Chairman, if I could just add something to that. The borough actually commissioned Boswell Engineering to do a traffic study, which we made part of the record. We presented to the court and to the special adjudicator, and despite that, the special adjudicator in her report stated that she believed that that was appropriate access. So,
That's my point. I know, but
we're going to keep fighting.
It's something worth fighting for.
Doesn't live here.
Something worth fighting for. Yeah, and that's clearly these people making these decisions, have any of them stepped foot in Oakland? You even see what the neighborhood is like? I mean, it's...
The McBrides have actually owned that property for...
I know, for decades.
And I've been on this board, I think, for 28 years. They've come in front of us numerous times for different proposals. There was always something going to be built there. And it was mostly more recently, more of a high-density condo-type development, but they just never...
Have they ever asked for the use of Judith Page in the past?
No. Now, I'll tell you what happened, though. Before, early on, they were able to access that property through Ramapo Valley Road between the diner and the tire place.
Yes.
They actually own that easement through there.
Okay.
But they changed, the DEP has modified the buffers between the streams, and there's a C1, what they call a C1 stream, runs down there, and they can't develop that piece of property now. So they can't come in Ramapo Valley Road. Had they done this 10, 20 years ago, they would have come in there.
And I also heard before with litigation that costs the town. I've talked to many people in here. I'd say 90% of them, it's for that very reason, is opening of Page Drive. So if TDC is watching, that's why we're all here and very upset. Thank you.
Thank you.
Jeff Schwartz, 172 Long Hill Road. We bought the house in 1987. We've raised our kids here, Dogwood side. The bi-county development was going to be next door to my house going in. New traffic light on Long Hill Road. Right way, which comes out of the office park, was going to be made from a one-way to a two-way street. They were going to take part of my front yard to widen Long Hill Road, make a turning lane into that. Long story short, we successfully fought that development, and we can fight these developments. My question is not about affordable housing. I did want to get clarification, though. If the Page Drive, you mentioned going in through Page Drive is going to be cut off by ordinance and all that. The entrance to the McBride is where? Thornton Road, right?
Thornton.
At the end of Thornton, where the cul-de-sac is,
Yes.
next to File Bank and by the water tower.
Through the industrial
That
area.
would, through the office park. We don't call it industrial. Not if you live
To
here.
clarify, just to clarify, the ordinance stipulates emergency vehicles through Page Drive.
Through Page.
No traffic through Page Drive, emergency access.
Correct.
Emergency
So that's-
vehicular access.
So that's good, that's great. That eliminates the whole Grove, Yorko, Page Drive traffic. But what that does mean is all the traffic is going to come up and down Long Hill Road, in and out of the office park, from both Colonial and Franklin Lakes that way, down Breakneck Road, up in Long Hill Road. I'm literally the Jeep Blue House across the street from the office park, I think everybody knows. And I watch every morning when people drop their kids off or at school at Barnstable. There are now 3 schools in the office park. Everybody comes out and makes an illegal left onto Long Hill Road because they don't want to go down Thornton and Bower and wait at the traffic light, which is always back. Tons and tons and tons of traffic. Now we're going to have tons more traffic. So my question is not about affordable housing or anything like that. My statement is more that thank you to you guys on the Board of Adjustment, the mayor, the town council, fighting all these developments. This is not about any one of these developments, and it's not about affordable housing. Unfortunately, there are state laws, and we don't have a choice. We've got deadlines, and we have to pass these ordinances. But that doesn't mean we have to have these developments. They can all be shot down. They can all be taken off the table if we make it too expensive for the developers to keep fighting. What we did with Bi-County is we made them fight for years and years and years, and they finally walked away. Another developer came in, we did the same thing, they fought and they walked away. Remember, every time they send a lawyer or attend a meeting or have to go through these, maturations to do all this stuff, it costs them a huge amount of money. All right? I don't care if they're from Texas or from around the corner. Make them fight. Stand up. Join the groups. This is great. Look how many, we got standing room only all the way out the door. This is terrific. This is what we need to keep doing in the future. And we know that none of you want these developments either. So thank you for fighting, and everybody keep on fighting. We're going to set up a group on Facebook that's just about fighting the developments. All right? So we can all get together, and if we're like this at every meeting, and we have to move the meetings to the senior center because there's more room, which is what we had to do with Bi-County because so many of us showed up. You got to show up. All right? That's the important thing. You have to show up at these meetings and tell these people that we don't want it. We've got steep slopes, we've got environmental concerns, schools, traffic. Make them do all these studies that cost them money, and eventually they're going to walk away. And that's what we need to continue to do. So thank you, everybody here.
Hi, my name is Sandra Sori, S-O-R-I. I live at 168 Page Drive. I've lived in Oakland since 1992. I've lived on Grove Street for 20 years. I've lived on Hickory. In 2018, I bought what I thought was the most beautiful property in Oakland. Unfortunately, that property shares about 600 feet border with the McBride property.
Can you talk louder?
My property shares 600 feet of border with the McBride property. It runs my whole side yard and down my driveway. So I'm one of two houses that exit onto Judith Lane. So I have, obviously I have personal concerns. But my broader concerns, which I'll talk about here, specific to this issue, are the environmental impacts. Well, I understand the need for the Borough of Oakland to comply with the Mount Laurel Doctrine. The doctrine explicitly says affordable housing obligations do not require environmentally destructive planning. And I feel like there's no planning in certain instances. So when we talked about the elimination of the protections for steep slopes and tree removal, that was, to me, it seemed like it was there was a concession made to this developer and this developer only. And it appears that it was not based upon any studies, engineering studies, but based upon the developer saying it was cost prohibitive, or I'm not sure what that term is that they use. So it seems like there was a fold on that for this developer. So I want to understand how this is consistent with the borough's master plan and environmental policies. Why was it given to this developer only?
Yeah, great question.
Do you want me to try to answer it?
Yeah.
It's a very difficult thing that this board has to struggle with, because when we go to approve these ordinances, you're right, we have, our job is to look at what's in the ordinance and say, is it in conformance with our master plan?
Right.
So when you see something like a steep slope ordinance being eliminated, you say, that's not in conformance with the master plan, right?
It's not.
So you have to, I guess, look into it a little bit deeper. You have to say, okay, also in the master plan is, we're agreeing to provide affordable housing. So in order to do that, we can't be putting cost generative items on a developer to try that could, possibly, reduce our affordable housing.
So it's rolling over to the developer and ignoring the environmental impacts of it.
It's a compromise. So, okay. So we may have to eliminate the steep slope ordinance, but that doesn't mean that the developer is going to build all over steep slopes, because for a developer to build on steep slopes is very expensive. There's a lot of earth moving. There's all kinds of costs associated with it. So
Chairman,
the
can I add
developer's
something, though?
not looking to build on
Yeah,
steep
and
slopes.
the big thing about the McBride property, there's obviously serious sensitive environmental issues
Yes,
there, right?
there is.
I'm chairman of the town's environmental commission too, so I'm in the environmental field.
Okay.
That property is going to have to get DEP permits. Now, the DEP permits, Mr. Schwartz, we remember, I testified with you back then when we were successful. The DEP is going to come in and have a public meeting on this, should the property move ahead, because like the borough engineer said, this thing may not pencil out at all. Okay. We have to put the ordinance in place to meet our obligation, but there's a lot of steps, and we were successful back 20 years ago for the Bi-County, because DEP came in, gave a public meeting. We had a crowd like this there, and it was wonderful. Everyone came up there and talked about the environmentally sensitive issues that could really affect it. And you know what? The DEP listened. They have the power that we can't. They are the ones that's where you make your pitch and your best statement.
Is very environmentally
And I am totally on board with all the environmental sensitive issues there. There's constraints that's called. We got a C1 stream, we got wetlands, we got steep slopes. But DEP is going to be the important player if this thing eventually goes to a site plan. When it goes to a site plan, that's when everyone makes their comments about the site plan. The DEP will have a public hearing, and we have been successful in past, so don't give up.
I won't. And I do want to make clear, I appreciate your efforts. I know that you've worked very hard to get to this point, and I appreciate the time the mayor has spent with me personally and my neighbors to talk to us. So thank you. I just, hope you do what's best for the town.
Thank you.
I'm Maureen Walters, 176 Hiawatha Boulevard. And I didn't realize you were so involved in the environment, but I want to know, I'm assuming there was an environmental study done on the area, if it was released to the public. And I'd also like to know if it included our endangered, threatened animals of Oakland. And I've been living here for 30 years plus. I've been in the Sandlot studying a bobcat survey over 22 years ago that was done right off of Fox, off of Page. So I'd like to know the environmental impact study you had done for the American kestrel, barred owl, red-shouldered hawk, and a bobcat, which there was also one found dead right off of the Skyline exit, which is also a corridor from West Milford that comes up through Burger King by the bank there, up to the Sand Hill lots. I've had people tell me I actually do mountain lion studies, but bobcats were in that area. And originally I was looking for bog turtles when they were building, 20 years ago. But I want to know if there could be an impact study done on these animals. I'd happily do it for free, but I'm one person, so I'd like to ask. I don't live in that area. I'm on the other side. But you can easily get owl calls at night if it's a barred owl.
We do.
The bobcats.
I caught one on my camera.
The bobcats sound like a girl being murdered at night. And that's why the woman called me. I get these crazy calls, and they literally on Fox, I don't know, there's a couple of houses, they were all out there, thought somebody was being murdered. And then, I asked her if I could hang a dead chicken in her yard, and she looked at me a little crazy because it was at preschool. But I'm just saying, these animals do exist there. They're all protected. Although the bobcat from endangered to threatened this year, just in a year, but the kestrel, I've seen there. Barred owls, I've seen there. Red-shouldered hawks, I wasn't too sure. I thought I saw one there. But I really like an environmental study done on the animals for here, as well as the people, because, they all bought this property with the aesthetic value of not having neighbors in their backyards and a nice place to hike. And, what are they going to get back? They're going to have townhouses, all this. We all know, we've all heard it. But we have to look at it, to go on the woman who spoke before me on an environmental perspective. and raise this red tape, because these animals do exist here. And I'm willing to prove it. I just need the help from some of the residents. And I just want permission to set up cameras on McBride Sandlot area.
Just so you know, there's nothing proposed right now. There's no project proposed. So when that time comes, there'll be a lot of, like Mr. Heyman mentioned,
Can I
environmental
still hang my
study.
cameras up and
Well, that's
do
up
my
to the
little
McBride.
footprints?
It's their project.
But I would really like permission to go on. I've been on that property for years. It's been a while. And I was doing large cat studies here off of Colonial Road 25 years ago. And it led to the bobcat here. So either way, I'm looking out for our people, but I'm also looking out for our animals. And I'd like an environmental impact study for the threatened animals that do exist in Oakland. I mean, you're gonna plow down a bunch of, you have these empty buildings, right, in Oakland, like everyone's saying. Let's use the empty buildings and the spaces that we have before we plow down a bunch of land off of what our town is named for, Oakland. These old oak trees, and we just keep plowing them down. So, I would like an environmental impact study, not only just on the slopes and the watershed, but on the animals that exist there. And we're not even talking about the insects, the little skipper, the blueskin dude. There's a lot of things. I'm just talking about the mammals and some of the birds that are there that people can just record on their phone. It's just as good. A call is just as good as seeing it, okay? They're all identified by that. We just have to prove that they're there. That's it. Thank you.
Hi, I just have a question. My name is Stacy McAleer. I live on 15 Whittier Lane. I've lived here, it'll be 25 years this year. I just piggyback on what the first speaker said and what she just said. Why can't we use existing buildings to build these units? Why do we have to build so many units? Because the builder wants to make so much money. Why isn't there a compromise? We have a lot of empty space in Oakland.
If I can answer that, Mr. Chairman? It's because under the process that was adopted by the state in 2024, we have to acknowledge the people that objected to the plan, and there were 3 objectors, so we have to deal with them. There were no other owners of buildings that came forward to say, we're proposing or we would permit affordable housing or housing of any kind to be built on our sites. So we were obligated to deal with these objectives.
That was 2 years ago. Did anyone approach them again?
I'm sorry?
Or, I don't know how it works, but can we revisit that?
It's the challenge process. They're the ones who came and challenged the plan during the 2-month process. These 3 developers, these 3 property owners. So that's it's a process. It's a process that was established by the legislation.
It's just a number. Doesn't mean we have to hit it.
Yeah.
You knock down all these developments.
Okay. All right. Thanks.
Okay. Thank you.
Good evening, I'm Stephen Quinn, 70 Grove Street. I just have a quick question. Has there been any discussion on opening up the Paper Road section of Nielsen Ave for development into the McBride property off Grove Street?
There's been no discussion about that. It might be environmentally.
Is it in the plans?
Yeah, I think it's in a wetlands area myself, but I'm not sure. But no, there has been no discussion about that.
Hi, I'm Christine Landale, 81 Iroquois Ave. I've lived in this town my whole life. I was born, raised, and am raising my children. I appreciate everything everyone is doing, and I know that if the time comes, we can't stop it. But to echo what the board president said, my concern is the schools. I'm an elementary school principal in a town that has met many of their requirements with affordable housing. And my school was bursting at the seams. 3 years ago, we had to go to the taxpayers for a referendum. They were not happy, but they passed it, thank God. And we have room for all of our students. But it was scary because if they didn't pass it, we didn't have room for them. And that's a very intimidating thing as a school leader and also as a parent. And it's a concern that I have for my children and for everyone's children and grandchildren who are in this room. So my ask is very simple, and it might be ridiculous and not an option, but if there is a way, if this all goes through and a day comes when they're building, is there a way to require any of these developers to put an initial investment into our schools? Or someone to help us, because it will be impossible for us to, if you do the calculations on the number of units and the anticipated number of students, it's always far more than what they predict, and we will not be able to fit them. So that is just, I know it's probably not an option, but I do just want to mention it, and hopefully it all works out. So thank you.
Thank you.
The answer, Chairman, is it would not be legal to do that.
Correct.
Hi, Carrie Odgers-Lax, 22 Grove Street. I just have a couple of questions, but I want to start by thanking everyone involved for the work that you've done thus far. It sounds like from the point at which they released the numbers, there's been an enormous amount of effort to whittle them back to try to do what can be done, so thank you for that. I'll second that I think we need to continue to fight with everything we have, every borough board, the council, et cetera. But I have a couple of quick questions. When we met with the mayor and we were speaking with Mr. Giblin, there was some discussion of, I had asked about Green Acres money or open space funding. Let's say this drags on forever, this block 3401, the McBride property, and if we wanted to put together a proposal to purchase that property with Green Acres money, my understanding is once it's rezoned as affordable housing, that that's no longer available. Green Acres funding isn't available. We kind of broached this, but we didn't kind of dig under it, and I believe someone said that there was effectively, there could be remedies for that. Is there anyone who can address that, that if we rezone this, I understand we need to, if we rezone this, and then it drags on and on and on, and there's an opportunity maybe to put this together, what does that look like? How, is there a legal process?
I'm not aware of it. I've never been through that process before. And I've been doing this a long time.
Okay.
So it's just something that doesn't usually happen.
Okay.
So I don't know the answer.
Okay. And just two other quick questions. Earlier this evening, someone brought up, could we rezone the office park to allow for housing there? And also it was stated about expanding the downtown, and that it was the sewer expansion that we were waiting on, and then we could take advantage of the zoning we already put in place for the downtown. Can we rezone the office park to allow an overlay at least for residential housing, and or rezone it entirely? And what does that, what's happening, I guess, with the sewer? When will that downtown be developable? Where are we with kind of that process?
I'll let you take the sewer question.
Oh, boy. So, sewers, as it is difficult for a developer to obtain permits and permission for sewers, it is also difficult for municipalities with the DEP to obtain permission for sewers. Having said that, so there's two components. One, it's money and the cost of building the infrastructure for the sewers. And also we have to have cooperation with the Northwest Bergen County Utilities Authority. We also have to demonstrate about water reallocation with the DEP. So without getting into too many gory details, there are still multiple steps that have to be taken place in order for us to see a project come to fruition. Right now, the costs are exorbitant to have that take place. We are still working on it. We're still working with the water reallocation. And what the water reallocation is that we would have to compensate for the amount of water that is going into the ground as part of all the septic systems, and have to purchase water from another entity in order to compensate for that. That has costs associated with that. Those costs are quite exorbitant. and plus we have to get permission for that. So there are many steps still have to take place to get to that point. So I can't say how many years at this point. When I first got here 8 years ago, they said we'll have them in 8 years. So I don't mean to be comical about this, but it almost seems like every step we try to take in that direction, there seems to be more regulations that come about that prevent us from doing that. So I know that that's not an acceptable answer, but that's the way it is.
The office park zoning?
You know, it's an interesting, something that maybe we should look into a little bit more. Not that it impacts what we're doing right now, but
understand.
We still have to deal with the objectors who file their objections within time. We still have to handle
That's
that.
the issue. We can't replace.
I understand
I think while everybody, and maybe I'm wrong, but what the impression I'm getting is that while everyone's asking about other buildings, they're not. The question is really, can we replace one of these two with the other buildings? And the answer to that is no.
No, I
so
understand
but that's an interesting question. Should future overlay, and that's the areas that could be considered for future overlay zoning, but not.
But then I have a kind of crazy follow-up. If it would take that many years for them to develop some of these other properties, right? Because they've got all kinds of constraints. I know this is pie in the sky. But if we beat them to the punch and met our number with things that aren't maybe as constrained, when we meet that number, do we meet that number and they can pound salt or no? Because we already have the agreements and they have to be allowed to develop.
Yeah. The point for us is not to meet the number, it's to make a realistic opportunity for other developers to meet the number. So the borough doesn't have to go out and build a single unit.
Right.
We have to do zoning that makes it, a
Right.
reasonable opportunity. That's all the borough is trying to do. If that gets done some other way, yeah, as long as we're immune, again, if we get past the March 15th deadline and we get substantive certification from the court, from Judge Carsten, we're done until 2035. That's what we're looking for.
Right.
So, there's a lot of things that could happen during that 10-year period, but it gives you that 10 years to make those other kinds of arrangements.
Thank you.
Thank you.
Hi, everybody. Pete Mazzilli, 48 Cherokee Trail. Also a trustee on the K-8 school board. I didn't want to make this meeting a minute longer than it needed to be. John spoke eloquently on behalf of the school board. The doctor here made some comments, and Mr. Schwartz, I just wanted to echo a couple of those things. All right, so number one, $25 million, right? Remember that number, because that was the cost of the bond that we didn't put before the town a couple of years ago when we started to really realize that development was coming and we were going to have our schools overloaded. $25 million. Alternatives like other buildings, other areas, fighting and buying time, I think is what I would like to be on record as being supportive of. We as a school board, in lieu of expanding the schools and spending that money, we negotiated with OLPH to utilize their school. So it did provide us with some relief. It's not a fix to absorb 4,000 new homes or 900 affordable units or wherever we land. So think outside the box, be creative. We don't have any other churches with schools that aren't being utilized, I don't think, in Oakland. So we need to just continue to think outside of just rolling over and accepting it. So appreciate the time, appreciate your guys' time, and I appreciate the council as well. This has been a close partnership. I want to make sure I'm on record as understanding, appreciating everybody's, we're all fighting for the same thing here. So thank you.
Hi, Jeff Petrowski, 34 Oak Street. I just have a clarification. Earlier tonight, you mentioned that the Robert property was zoned as RA4AH. Is that correct?
I think it's 5. That's off the top of my head. The RA5AH.
I'm sorry if I did. It's definitely, it was rezoned for an inclusionary type development. I might have given the wrong zone name.
Yeah, I believe you did, and that threw me, so.
Is it 5 in your?
In
It's
my
either 4 or
information, it's
5.
I think
five,
it is five.
and
Yeah,
there's an ordinance that specifically describes that.
Correct.
That even talks
You're
about a
correct,
road
thank you.
between
It's the-
Terhune and Oak Street.
It's RA 5AH. You're correct, thank you.
Okay, that was my question. Thank you very much.
That was an easy one.
Hi, my name's Joe Quaglia. I live at 31 Long Hill Road. I just moved here a year and a half ago, actually, with my wife. Just want to thank everyone. I've clearly moved into a passionate community that you guys care about your community and making sure it's a good quality of life. We just had a baby boy about 4 weeks ago. Hearing about the impacts, potential impacts to schools is obviously concerning. Was not fully aware of that. I'm just getting to know the community. Thanks everyone for explaining that. This is a place we intend to raise our son and have a good education. Also, something I can speak to. My property is adjacent to this McBride property. I can speak to environmental impact. Just in the past year and a half, it's truly an incredible piece of property. Mr. Heyman, I believe you speak about it from the environmental side. I know there is a natural aquifer under the property with fresh water and native New Jersey brook trout, which I believe are protected. We've seen barred owls, we've seen bears, we've seen foxes, we've seen coyotes. We have seen too many animals to count. Keeping a notebook, it's a really special piece of property from an environmental standpoint. I understand, we don't own the property, and another party owns the property, and but I guess just want to go on the record and say the environmental impact should be very closely considered and adequate studies performed.
And just so you understand, that property is 66 acres, and I think maybe 25 acres we're saying might be, so 40 plus acres of that property will never be touched. Okay, and it's because of that stream that you mentioned and the buffers around that stream, that's the main reason. So,
Okay.
So that's the good news.
I understand. One thing that we've kind of thought about that, but the water, sewage runoff, waste from construction and just general living impacting those streams coming, down from because it's top of a hill, would be a consideration. Okay. Thank you.
Thank you. Everybody.
Hi, I'm Tricia Petrowski. I live at 34 Oak Street. How's everyone? This has been very civilized. I just have a lot of respect for the way the town is communicating with one another tonight. I think it's terrific. We should be proud of our example. Everybody remembers Hurricane Floyd in 1999? Okay, I'm still getting over it. But when I got saved by the National Guard after 2 days at the radio station in Pompton Lakes, we tried to stay on the air as long as we could. Our generator was underwater, but we made it. We still were able to help out. They took me up, and then someone was able to drive me from somewhere on West Oak Street past Burns Hardware to get back to my home. And Burns Hardware's door was wide open, the lights were on, it was nighttime with a sign that said, "Take anything you want, it's fine." And the community respected it. So why am I mentioning that? So everybody remembers how intense that flood was. I probably am wrong, my memory is really bad. But didn't the Army Corps of Engineers do work on the Ramapo River area so they could help Pompton Lakes and us from the runoff up the hill?
Yes.
Will building on the property behind my house on Oak Street, in that patch of woods that's back there, will that have any impact on runoff? Think of Willowbrook Mall when they built that in the 60s. That was on a wetlands area. Why that was ever approved, no one will know. But it's underwater a couple times a year itself. What about the properties down from us? Now, my house doesn't flood. Oak Street, believe it or not, is a little hill. It's on an incline, so I'm safe. But I'm actually concerned about the integrity of the work that was done along the banks of the Ramapo, how it will affect the gates down by the falls in Pompton. I had people show up at the radio station after the water receded that were in tears because they had nowhere else to go or what to do. I went past their houses a few days before that in a boat, and the water was up to the roof line of two-story homes. So do we have to check with the Army Corps of Engineers or whomever was in charge of that abatement to make sure that more people, more structures will have any impact on it? Do you know what I'm saying?
I know what you're saying.
Yeah, my memory is so bad, I forget half the time what I'm saying.
So we're not at that stage yet with that site. We'll go through a whole site plan approval process if the developer moves forward. And I think Mr. Yakima can answer your question about the runoff.
Okay, great.
Yeah, so that would come under the DEP regulations. The current DEP regulations, which get stricter every 1 to 2 years, and they've just recently got more stricter, is that that area is forest, and the developer, once he takes the trees down, he has to actually reduce the amount of runoff coming off of the property, even though he has impervious pavements. And the amount of reduction is significant. We're talking, 20, 30, sometimes 50% for the certain types of storms. So that's a DEP function that reviews that. They're very strict with that. And so all the runoff from those surfaces will probably be transferred for ground saturation to recharge the aquifer. But we're not at that point quite yet, or not even close to that point yet.
It's just something to consider.
We will go through a whole study, a drainage study.
If the council needs assistance researching or finding contacts from any of the officials, whether it's the Army Corps of Engineers or what have you, I'm fairly resourceful. I'll be happy to reach out. I just keep talking until they answer.
Dave Richardson, 320 Ramble Valley Road. I grew up in this town. I've been here a long time, and I've watched it change from a little one-horse town to what it is now, right? And it scares me, right? What's going on with the traffic? I live right across the street from the library. I can't get out of my driveway in the morning or in the afternoon. There's 20, 30 cars all the way on both ways. I gotta hope somebody's gonna let me out. What's gonna happen with all these, these new cars and these new families moving in, right? The gentleman down there with the black top on, you were up here before? You live at the bottom of Long Hill Road?
Yeah.
Right, the house in the back?
Yeah, exactly.
Yeah, that was old Doc Mitchell's house. I used to fish that stream back. Right, I understand when McBride was gonna develop that area over there, right? That the state come in and they electroshocked those brooks to see how many fish were in there, because it's loaded with native trout, brook trout, brown trout. And they said, no, it would have to be what, like an 80-foot setback?
It's like 200 foot,
whatever it was.
300 foot buffer.
Yeah, and that's what I guess they bailed out of it. But, I mean, that area back there it's beautiful. I mean, there's just so many fish and animals and stuff. Look what they did behind the high school. How many animals were displaced when they took all that? I got so many deer in my backyard now. Right, I have 30 arborvitae trees that they totally destroyed. They can't keep out of them. I've netted them, I sprayed them, and I did, So it's a shame what's going to happen here, right? Between the traffic, the environmental impact of all the animals and everything else, and so.
Thank you.
Thank you.
I'm going to follow my friend Dave. I've been living in this town for 66 years.
Your name, sir?
Resident.
Name, please.
Name?
Name and address, please.
Oh, I'm sorry. Ron Wright, 24 Dogwood Drive. My father's picture is hanging over there. And if anyone, I guess, who enjoyed the pristine environment and so forth of Oakland, I have, used to jump off the trestle into the river, swam in it, fished in it, whatever. And I've heard a lot of interesting points here tonight by different people. And we have a lot of points, valid points to argue. And I think that if we get the numbers up, like we have this group here tonight, but I've had parties as big as this in my backyard. And there's what, 14,500 people living in this town, I think? So there's strength in numbers if we can get enough people together to fight this thing and maybe make minimal contributions out of our own pocket to hire the proper, I'm going to say counsel, and I don't mean lawyers, we need lawyers too, but people who know how to fight these kinds of things. We will win because there's strength in numbers, and we have the arguments to support that. So I hope that comes to fruition, and thank you.
I'm Steve Mawini. I live at 98 Grove Street. I wasn't planning on speaking today, so I hope I get a point across here. I've heard a lot of concerns about this development coming up, or the possible development. And it's my understanding, and I'd ask a question to the experts here. It's my understanding that if these ordinances don't get passed tonight or by the 15th, all of the problems that everyone expressed, all the issues that everyone has concerns about, the water, the sewer, the schools, the animals, all of that gets worse. Is that accurate? I just want to make sure everybody in this room understands that, because from some of the comments it wasn't explicitly clear. I mean, obviously, the town, we thank you for your work. Obviously, they have our best interests at heart. Any developer that comes in here to build on the land in this town has one thing at heart, and that's profit. And they are not going to care. They're going to run roughshod over this town if this is not passed. So I just want to make sure that that I'm right about that, first of all, and that everyone's aware of that. Secondly, I got just a question about Page Drive and the access. Obviously, that's a concern. There's a couple things that I've heard that sort of conflict. Number one is the ordinance going through tonight. It's my understanding that the ordinance says there will be emergency access only to Page Drive. The other thing I've heard is that some of the developers, as well as I believe it was mentioned before, a special adjudicator, right, said that was not really necessary. That was that could be used as a potential point of traffic flow. So going forward with this, what's the situation there? Is my question. Does the ordinance hold? Can that be fought? And if it is fought by developers to try to open that up, what do we do to try and make that not happen? Is there anything we can do? That's a fair question. That's my question, and I'll step away. Thank you.
If I can answer that. The answer is yes, either as part of their challenge to our attempt to meet our affordable housing obligation, or as a separate action. Yes, the developer could challenge that part of the ordinance, or the ordinance in its entirety. So that's a possibility, and without going into any detail about how we would fight that, the answer is it's clear that the mayor and council will fight that.
Good. Mr. Chairman, can I just put a finer point on that? For the people that don't know, I live on Page Drive. And I also am very familiar with the sand pit, having lived here my entire life, and how important it is. And that is a red line for us for the access coming through Page Drive, because of exactly everything you said with the bypass traffic coming through the industrial park, coming in from Wayne, coming down Page to cut across, because they don't want to sit on 202 traffic. So to answer your question, the answer is yes.
Okay, do we have anybody else from the public?
I'm Mitch Roy, 96 Grove Street, Steve's neighbor. 33 years ago, I moved in, and I was sitting in my living room, and we heard the mailman come and deliver something to the door. It was a certified letter that they were building True Green Chem Lawn in the back by the sand pits. We fought that vehemently, and we won, and that's great news. But it's just ironic that 33 years later, we're faced with the same story. So I have a question for Mr. Heyman. The sand pits, I don't understand sand to be indigenous to this area. I'm curious, what was there before, and is there a possibility that whatever was there before potentially put something in the ground that would be dug up once new development would occur?
Probably not, but I can't say for certain. But there's certain sand areas, like I'll get into a little geology because I'm a geologist too, by the way. That could have been deposited by like the glacier type stuff. And there's a sand, literally sand pit there that has been there. But something being there prior to that, I just don't have the history of the town, so I can't speak to that. But the water coming out of there, the C1 stream, we've talked about that a bunch. There's some really serious environmental concerns there that, again, I mentioned earlier, the DEP is going to have to address, and then that's where everybody in this room should show up to that meeting with the DEP and protect.
I appreciate that. So I did find something that there was some kind of a factory or industrial facility back there a long time ago. And anything that was done a long time ago predated, for sure, any environmental regulations that are in the state of New Jersey now. So I implore upon you to investigate that, look into it, because if you don't know, I guarantee you there's some other facts.
We have the Historic Society man right there, so you two should talk.
I hope it be considered in the right scheme. Another observation I have, living right opposite the tallest part of that hill, is that right now, if you look from the rains last night and just with the snow that melted there, it runs water from the hill. It pours water. Look, it's an underground stream that feeds the stream that runs behind Grove Street. So anything that delivers groundwater, more groundwater, is just going to take any pollutants, dump it into that stream, right into the Ramapo River. That's our drinking water. So I'm assuming that that's all going to be investigated and looked into as part of it.
If this moves ahead and application comes before us, all those things have to be addressed and will be discussed in detail, and especially specifically for the McBride property, you have the DEP involvement. So that multiple layers in the future.
Great. And I also know in this environment that we're in, environmental regulations, there's serious moves to cut back. I'm just concerned that, as this progresses, and it might take time, that they'll cut back some regulations that could potentially protect us now, but might not protect us a few years down the road. Anything?
New Jersey has very strict environmental regulations, but I can't see New Jersey's regulations changing.
Okay.
That's my personal opinion.
And I just, affordable housing, I kind of find it ironic because when I hear 20%, I think it's mostly, it's not so much affordable housing, it's mostly unaffordable housing, 80%. I don't get the nomenclature. So thank you.
Thank you.
Hi, good evening. My kids say I'm really loud all the time, so I hope that comes in handy right now. My name's Karina Marble, 166 Page Drive. Some of this is redundant, but I'm way too emotional to ad-lib. Okay, get it together. 12 years ago, thank you. 12 years ago, when my husband and I were looking for a home, we pulled up to our house and immediately, I don't even think the car was parked, and he said, "This is the one." We had looked in other towns at houses that were way better than the house that we pulled up to, but we were like, this is it. The property, it was perfect. We were about to be married and knew that this was where we wanted to raise our future children. Sorry, if any of you know where I live, you know that this is completely changing our life, as many of us, but we're on the dead end, and it felt safe. It's protected woods behind our home. It felt permanent. It was quiet, private, and surrounded by nature. That's why we chose to live there and put all of our savings in our investments. Now our children are 9 and 10 years old, and they learned how to ride their bikes. They skateboard, rollerblade, play outside, not on screens. In the summer, they swim in our backyard, just a few feet away from the woods. We regularly see deer, fox, other wildlife passing through. If this development moves forward as proposed, everything about that environment changes. Turning a dead-end street, which I know you're saying that that's where the red line is. Money seems to be talking. And if this developer wants to bring us to court, it's amazing how you're saying that you're going to fight this, and that's where you really draw the line, but it seems like money could win over that, and it's terrifying. And we think about, look at the laws for the properties, well, one of the other developments, I forget which one it was, but they knocked down hundreds of trees, and they had the ordinance, they had the tree protection ordinance.
They 1,000 more than they were supposed to. You're talking about by the high school,
Yes.
I think. Yes.
They had the ordinance.
They took 1,000 trees extra and just paid a check to make up for it.
Yes. So they had the ordinance, but they just took the fine and paid, what, 30 grand or something for it? We are waiving the tree ordinance. I don't understand that. That's something I really, really hope I can't understand why we would waive something that even a developer, like if we're, all right, talking about fighting, right? But it seems like, wouldn't that be making it easier for them? We're saying they don't have to have that. The access to Page Drive is way more cost whatever for them, so they'll just pay the extra to cut into my yard, Jim's yard, Sandy's yard. Like, they would just destroy not only where my kids play, but they would have to cut into my property. And I know you're saying, you know, we're against eminent domain, but where my property line would be, and they take it, you would be on my pool. That street would be at my pool. At my pool. So, my son wanted to come tonight and say, can I tell them that I don't want this because they're gonna see me swimming? That's so creepy. And then my daughter was like, what? That's so gross. So you're talking about multiple level buildings right there, at least 3, according to that image that they proposed. That would be on top of our properties, looking over our little children, swimming and playing, and no amount, let me stick to my script because I don't know. No fence or row of trees could realistically block that. They'd be on the slope and they'd be multi-level. There's no shot for my ranch and my pool to not be. And I mean, numerous people secretly watching my children from their windows. It's disgusting. So our privacy that we counted on when we bought the home would be gone. This isn't about just inconvenience. It's about a loss of privacy, safety, property value, the natural environment that made this neighborhood what it is, and I think that that's what we all agree on here. I'm also deeply concerned about the larger impacts, like we talked about traffic, school capacity. I find that also very concerning that we're not allowed to even question that until after the fact. We're not allowed to say, what's this gonna do to our schools, right? Wayne, all the things that we're saying have to be addressed, and they have to get the okay and the approval and do it the right way. Wayne got all those approvals, and they built over a mine shaft, and the new development started sinking. They opened a new school for that development. It's sinking, and they got rid of all the teachers. I now work with some of those teachers that got hired and let go for that new school. We've already seen the warning signs. So the recent development behind the high school with 190 units required the fire department to respond 7 times in 12 hours just this week. 7 times.
What?
The fire department posted it and saying like that we had to go. This is a high unusual call. We had a very busy day. It was that new development in the back.
Time out. I'm on the fire department. We went once.
Okay, well then the fire department posted it, so if I have this information.
They had 7 calls that day.
Yeah.
1 to the developer.
Okay, thank you for the correction, I'm sorry.
I think it's our first call we've ever had up there.
Oh, okay, well, thank you. But I would do, if we are not addressing that there may be an increase in things because just doubling our population size, what would that do for getting into the woods for 240 units? As I think someone may have brought up before, that Oakland once faced a serious flooding problem, so the town brought in
the Army Corps of Engineers to help resolve it. And from what I understand, those solutions helped Oakland, which is great, but surrounding towns downstream now experienced increasing floods. So there was a lot of buzz about the towns around us that they already had to pay the price for Oakland's flooding because of the in the past. So are we potentially finding solutions for us, but then creating others for the regions with this plan? I also was very informative tonight about the having to do this so that we don't lose our immunity. I get that. It's a problem. It's a problem. I understand that, and you are in a tough position. This is not something that we can blame on one person or one thing. I understand that. But the biggest issue to me is the waiving the ordinances that would help us not have this development. We're not waiving it. Where is it printed? The steep slope. The steep slope. Yeah, I'm sorry. The steep slope and the tree protection.
I could address that, Mr. Chairman. The ordinance waives the borough's steep slope ordinance. However, there is also a DEP steep slope ordinance, which we are not talking about. We don't have the right to waive, and they're still going to have to comply with that. And that's any slope that's 15% or greater. So they're going to have to demonstrate to the DEP that they meet their requirements.
Okay. Okay. I think that I chose Oakland because I believed it was where families and nature were protected. And I hope tonight I can tell my children that this belief was right. So thank you for everybody's time.
Good evening, Steve Quinn, 70 Grove Street again. So tonight, after listening to everything, I realize that the board is in between a rock and a hard place. If we say no, we lose control. If we say yes, at least we control the situation. We don't want it. I don't want it. Nobody wants it. But if we give it up, it's a free-for-all for these construction companies to come in and do whatever they want. So we have to vote yes. And then we control it. We control the situation, ordinances, rules, regulations, make these developers lose money on these situations. But if we don't vote yes, and it sounds terrible, but if we don't vote yes, we've lost the game. All these things we talked about tonight are going to happen. They're going to come in, and it's a free-for-all. So I appreciate it, and it's a very difficult situation you're in. It really is, and my heart goes out to you, but we're in between a rock and a hard place. And better we control the situation than somebody, an outsider. And we can, litigation, we can spend years and years and years and years with these developers. You know, it's just the beginning. You know, so we have to move forward. Nobody wants it, but we have to, and we control it. Thank you.
Can I request that future meetings, maybe the town gets notified through the reverse 911? Because I didn't, even the meeting that was the short meeting back in June 23rd, I saw that you said you put it in the newspaper. Who gets newspapers? I do not. Can you put it on the reverse 911?
Yes. You know what we can do? Maybe not the reverse 911, but we can send out to the emails and the text blast. We can do that.
That would be great because and maybe say let's have it at the high school or at Indian or at Valley to say we're having a big meeting.
Right. So just so you know, the planning board meetings all take. I'm sorry, Mr. Chairman. All the planning board meetings take place at the senior center, and that's a very large room. So we'll be able to come.
We're going to bring lots of people.
Yeah, we'll find a school.
Okay, just let us all know. Thank you.
Can I just say one thing really quickly? The Bi-County development that we fought also had affordable housing as part of that plan, even 20 years ago. So this is not something new. You know, we can fight this even with the affordable housing. That's not the issue. The affordable housing is not the issue here. It's the developments themselves.
Hey, Steve Mahoney, 98 Grove Street. I know everyone's tired. Obviously, I don't make this take any longer, but I thought that I didn't understand that the steep slope ordinance that was being waived was the town only, and there was an actual other steep slope ordinance that still had to be?
There's a DEP steep slope ordinance.
That's fantastic. That's great. That's great to know. My question is it the same thing with the trees? With the tree ordinance?
There is no state tree replacement ordinance, no.
Okay. Okay, that was the question.
Anybody else?
I just have a question about the Leone property. This is for Caroline Ryder. Appreciate your presentation. I appreciate all of your hard work on this. It's and the council, the planning board, and the professionals. I noticed as I was reading, there was a section, and where I found it was in the report, which is posted on the Borough website. I recommend everybody read that, because that would answer a lot of questions. Caroline went through it and detailed the process of how we got here. And there's a lot more detail in there. But on page, sorry, I don't have my glasses, but on page 36, there was a determination that the Leone property was eligible to be considered for what we're doing now. And I forgot the term. But it was indicated that there were no historic structures on the site. And I wanted to find out, how was that determination made? Because there's a house that dates back to 1920, according to some quick internet research. And also there's a barn and some outbuildings. And I checked some maps. The 1912 map does not show the property, so it is probably around 1920. So I was wondering if there was a determination on that by analyzing it, its architecture, researching its history, that it was not historic, or was it just an absence of having a survey done?
So I believe that reference has to do with the historic register, the state and national historic register.
Mm-hmm.
Is that what you're asking?
I'm asking how did T&M determine that?
I believe that's my recollection. Is we looked at the state and national historic register. Are you saying these properties are on the register?
No, I'm saying that they probably were not surveyed. And because the survey was done in 1982 to 83, and that was a driving survey, and it's possible that property was missed. And it might have also missed the 1999 revised survey. So I was thinking that it might not have been investigated. But I also noticed that I was wondering if it were a historic property. I'm not sure, I would have to research that, but if it were a historic property, would that make a difference?
It's on the register. Only if it's on the historic register.
Right.
And I believe, the last I looked, the property owner had to agree to have it put on the registry. And clearly that is not going to happen.
Yes.
In order to be on the registry, not this property. In general, a property owner must, I think is what you're saying, not this property owner.
Yeah.
Called out.
Yes, I understand it would have to meet certain criteria as well.
Right, yes, there's a whole criteria to be put on a register.
And the property owner would have to consent to it. So. Correct.
Right, but I know this is something you've been talking about.
Yes.
I've seen you at all the planning board meetings that I've been at and the council meetings that I've been at as well. Somebody said it tonight, keep coming to meetings, and of course your topic is different, but you've certainly been following that mantra.
Okay. I was just wondering if it had an impact on this, but thank you very much for your answer. And I appreciate, you're all very tired, so I will stop. Thank you.
Anybody else?
I'm not speaking.
Okay, I'm not seeing anybody else. Last chance. Okay, motion to close to the public.
So moved.
Second. All in favor?
Aye.
Good. Aye. All right, so we're back. We haven't got too far on the agenda. We're still under public hearing, amended housing element and fair share plan. so we've heard from our planner, from our attorney, we've asked questions, we've heard the public comments. Would somebody at this point like to make a motion to either approve or deny the amended housing element and fair share plan?
I'll be the brave one. Reluctantly, I will make the motion
I'll second.
to approve the plan.
Okay, we have a motion and second. Andrea?
Andrew, second.
Okay, any further discussion from the board?
I think we're all upset.
Okay.
Mr. Chairman, just point of order, are you doing these all one time?
No, this is just for the, this is just the,
Okay, yep.
yep, the plan. Okay, roll call, please.
Mr. Clark?
Yes.
Ms. Levy?
Reluctantly, yes.
Mr. Marskovetra?
Yes.
Mr. Connolly?
Yes.
Mr. Heyman?
Yes.
Councilman Talamini?
Yes.
Mr. Lith?
Yes.
Mayor Kamala?
Yes.
Chairman Potter?
Yes. Okay, so that is adopted. It now goes to the mayor and council for their approval. Now we go to the ordinances. There's 5 ordinances. They've all been introduced by the mayor and council. Our job is to review them and determine whether they are within the guidelines of our master plan. So we'll start with the first one, 26 Code 983. And by the way, whether if we do, whatever we say, if we say we like it, we don't like it, it still goes to the mayor and council for their approval. They don't need our approval. It's just we review them and give them our opinion, and then they decide. They adopt the ordinances.
It's an endorsement.
It's an endorsement of the ordinance, correct. So the first ordinance, 26 Code 983, ordinance to amend the Borough Code to include a new affordable housing and development fee to conform to state requirements. Caroline explained all that. It's basically a boilerplate from the state, okay, that has been turned into an ordinance for Oakland. So I'll entertain a motion to endorse that ordinance.
Mr. Chairman, I would suggest that ordinance is consistent with the housing element that you just adopted and with your master plan.
Correct, right. So keep in mind that we just adopted this housing element, which changes our master plan. So when we decide whether it's in conformance with the master plan, we're assuming, that housing element is part of it. So, motion,
Chairman.
Second.
Okay. Mr. Connolly and Heyman. Okay, any discussion? Okay, roll call.
Mr. Clark?
Yes.
Ms. Levy?
Yes.
Mr. Marskovetra?
Yes.
Mr. Connolly?
Yes.
Mr. Heyman?
Yes.
Councilman Talamini?
Yes.
Mr. Lith?
Yes.
Mayor Kamala?
Yes.
Chairman Potash?
Yes. Okay, next ordinance, 26 Code 984. This is an ordinance to amend 59-53.1.1 of the Borough Code, and this is for increasing the density in the downtown 1 overlay zone. Motion to,
Excuse me, Mr. Chairman. I'm sorry to keep interrupting you. I
Yeah,
just wanted
please.
to make sure it's clear that it increases density and also clarifies the affordable housing set aside as 20%. Sorry.
thank you. Feel free to chime in anytime.
And I would also, since I already interrupted you, want to tell you that I think that this is also consistent with our master plan, because we literally just adopted the housing element. Also, which we're going to be speaking about later, in 2023, the board updated its land use plan to reflect the changes from the last housing element. So therefore, this anticipation of this type of development along Ramapo Valley Road, I feel is consistent.
Thank you. Any further discussion from the board? Okay, roll call?
Did we get it first?
You don't have a
So
motion.
I thought we-
Okay.
I'm sorry.
So moved.
We'll keep you on.
Connolly.
I did.
List Connolly.
Oh, Mr. Marskovetra? Okay. Okay. Mr. Clark?
Yes.
Ms. Levy?
Yes.
Mr. Marskovetra?
Yes.
Mr. Connolly?
Yes.
Mr. Heyman?
Yes.
Councilman Talamini?
Yes.
Mr. Lith?
Yes.
Mayor Kamala?
Yes.
And Chairman Potash?
Yes. 26 Code 985, ordinance to amend 59-53.2.1, which is the downtown 2 affordable housing overlay zone. Caroline, you want to chime in on?
All you're doing there is verifying is confirming the 20% set aside.
So moved.
So it's consistent.
Yeah. And we have a second?
Yes.
Okay. Discussion. Roll call.
Mr. Clark?
Yes.
Ms. Levy? Yes. Mr. Martzkovich? Mr. Connolly?
Yes.
Mr. Heyman?
Yes.
Councilman Talamini?
Yes.
Mr. List?
Yes.
Mayor Kamala?
Yes.
Chairman Potash?
Yes. 26 Code 986, ordinance to amend the land use and zoning ordinance to create an affordable housing district for Block 3301, Lot 2, Block 3401, lots 11, 12, 1940, 43, 52, 53, 57, 58. This is the McBride property, and in connection with the borough's affordable housing obligation. So here, once again, Caroline, you say it so well.
So this is the rezoning of the McBride property. This is a little, so of course it's consistent with the housing element which we just adopted. Your land use plan, actually, your land use plan from 2000 identifies a portion of this property for multifamily housing in connection with your affordable housing obligation. Approximately 10 acres of it, the western 10 acres. Your land use plan in general obviously recognizes affordable housing obligations, what COA, which doesn't exist, et cetera. But your land use plan hasn't caught up with your housing element due to the timing we've been talking about tonight.
Right.
So I don't believe that your land use plan identified or anticipates multifamily housing in this area.
Thank you. All right, I'm told one of those doors has to stay open, so it's open.
Sorry,
Okay,
do you need me to repeat that? Because you were involved in the door.
I think we're good. All right. Motion?
Oh, sorry.
Second.
Okay. Discussion. Roll call.
Mr. Clark?
Yes.
Ms. Levy? Yes. Mr. Martzkovich?
Yes.
Mr. Connolly?
Yes.
Mr. Heyman?
Yes.
Councilman Talamini?
Yes.
Mr. List?
Yes.
Mayor Kamala?
Yes.
Chairman Potash?
Yes. 26 Code 987, ordinance to create new inclusionary zone District 1 for 129 McCoy Road, Block 4004, lots 4 and 5, Leone property, Borough of Oakland, Bergen County, New Jersey. Same.
I would offer the same comments. I was remiss with the last ordinance in not mentioning that there's already discussion in the borough of updating its master plan, both from the re-examination report that needs to be done this year, and then just in general because of this process. And my apologies for not mentioning that with the last ordinance.
Okay.
But everything else is the same.
Okay, motion?
Motion.
Second.
Okay. You got the second? I'm not sure what else. Okay. Discussion, roll call.
Mr. Clark?
Yes.
Ms. Levy?
Yes.
Mr. Martzkovich?
Yes.
Mr. Connolly?
Yes.
Mr. Heyman?
Yes.
Councilman Talamini?
Yes.
Mr. List?
Yes.
Mayor Kamala?
Yes.
Chairman Potash?
Yes. Okay, now we move on. Memorialization, do we need to do that, Greg? Or do we just basically do it?
Yeah, I would
Say memorial.
consider, yeah, those roll calls were on the resolutions that were prepared in advance of the meeting, so I think you're done.
We're done. No need to memorialize because the resolutions were already done. You guys all saw them. I'm going to sign them. Okay. Bills to be paid, we have budget 1 through 3, escrow 1 through 5. Motion to pay the bills, subject to availability of funds.
Who first?
Tommy Connolly? No. Mr. Heyman. And Andrea, second.
Thank you.
Give the other end a chance.
Mix it up.
Okay, roll call.
Mr. Clark?
Yes.
Ms. Levy?
Yes.
Mr. Martzkovich? Mr. Connolly?
Yes.
Mr. Heyman?
Yes.
Councilman Talamini?
Yes.
Mr. List?
Yes.
Mayor Kamala?
Yes.
Chairman Potash?
Yes. Approval of minutes for February 12th, 2026. Motion to approve.
So moved. Second.
Discussion, nothing, Greg?
We gave.
All right, little tweaks? Okay,
One little tweak.
good.
Okay.
Roll call?
Mr. Clark?
Yes.
Ms. Levy? Yes. Mr. Marskavatra?
Yes.
Mr. Connolly?
Yes.
Mr. Heyman?
Yes.
Councilman Talamini?
Yes.
Mr. Lift?
Yes.
Mayor Kamala?
Abstain, I was not present.
Oh, that's true. And Chairman Potash?
Yes. New business?
Mr. Chairman, did you do the escrow?
Yes.
I did.
Before the comments.
Yes. Any new business? Anything important enough to discuss at this moment? No. Old business, we're good? Okay. Next meeting is April 9th. Back to the Senior Center, 7 p.m. Motion to adjourn. So moved.
Second.
All in favor?
Thank you.
Adjourned.
Thank you, everybody.
Thank you very much.
Talamini. Hey, Russ, let's go. Oh, he'll talk your ear off. You don't have any ears left. Make sure I got my agenda ready here.
Do you want a hard copy?
Oh, I got it.
You have it?
I should have it. Is that right?
Yeah. Tough times.
I'd wash the pit.
That was killed in 9/11 too. Anytime you think about, I know.
Are our professionals ready?
Yes, I'm here. Yes,
Russ,
Mr.
Pat, are you
Mayor.
ready?
Yes.
Ready. Everybody on this end of the day, so we ready?
Yep.
Yes.
All right. I'm going to push the button so they know.
We've been on a shuffle.
All right, meeting called to order. This is the March 12th, 2026 Mayor and Council meeting. Would the clerk read the statement of compliance?
This meeting is being held in accordance with the Open Public Meetings Act, NJSA 10:4-6 et sec, having been duly advertised and posted in the municipal building in compliance with NJSA 10:4-8D. The meeting will adjourn no later than 10 p.m. unless the majority of the council members that are present vote to extend the time. And I have an additional statement to make, Mayor. This statement is to advise the public that Governor Phil Murphy signed PL 2024, C.106 into law on July 10, 2024, which amended provisions of NJSA 35:1-1 et sec governing legal public notices in New Jersey. Effective March 1st, 2026, municipalities are required to publish legal public notices on their municipal websites. In accordance with this law, the Borough of Oakland posts all official public notices on the Borough website where they are available for public review.
Public notices may be viewed at https://www.oakland-nj.org/about-borough/pages/public-notices.
Can you repeat that?
All dashes.
All right, all rise for a pledge of allegiance and a moment of silence. Councilman Pignatelli, would you lead us in the pledge?
Yes, thank you.
I
pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
All remain standing for a moment of silence. Thank you. Would the clerk call the roll, please?
Mayor Koala,
Present.
Council President Talamini,
Here.
Councilman Eilert,
Here.
Councilman Pignatelli,
Here.
Councilwoman Rose, here, Councilman Saliani.
Here. Okay. I don't really have a mayor's report, but I just want to read a letter that I wrote. But prior to doing that, I just want to acknowledge the planning board meeting that just took place for the last 2 hours. Clearly, there was a lot of confusion with the affordable housing ordinance that we are going to put in place. And with the hearing with the planning board, the residents really had an opportunity to ask a lot of good questions. There was good back and forth to really kind of diffuse, and so the resident can understand the position that we've been put into. So I just want to acknowledge the chairman and the planning board for the fine work that they did. Now, I just kind of want to read this into the record. Friends and neighbors, I want to level with you about why Oakland is being pushed into these affordable housing decisions and why it feels like everything is happening all at once. I did not run for office to turn Oakland into something it's not. I grew up here. I see we have Danny DeLee in the back. He grew there. We have Mr. Eiler and his family. He grew up in this town. We have Miss Rose, who grew up in this town. What else am I looking at? Well, Pat's old enough to have grown up in this town. But so, I mean, and Eric Shawback, I went to school with Eric. So, I mean, we're looking at 360 years of people living here, people that really care for this community. Many of us moved here precisely because we value the character of this community, quieter streets, the trees, lower density neighborhoods. I hear your worries about traffic, flooding, school crowding, and about preserving what makes Oakland feel like home. I not only agree with you, I stand with you. That's why for the last year, the governing body has engaged in multiple public hearings with the help of some of the best experts and in the state, regardless of political affiliation. So I just want to really commend our planner, our attorneys, our engineers. I mean, we couldn't have done this without you. This has been such a laborious process. But we are operating under state-mandated legal framework that was designed in Trenton, not in Oakland. This was put together in Trenton. Under the New Jersey Constitution, the Mount Laurel Court decisions, and now under new legislation, every town is mandated to create a realistic opportunity for its calculated fair share of affordable housing. The most recent law set hard fourth-round deadlines, including requirements that towns like ours have implementing ordinances in place by March 15th, 2026, if we want to stay in compliance and maintain the protections from builders' remedy lawsuits. And that's why these two meetings were put back to back. We had to have the planning board meeting prior to the council meeting, and I recommended that both meetings take place in council chambers so that the public, we can watch in real time and we can record both sessions here for the people that could not make it, so that we can really get that information out there to everybody. So what is a builder's remedy lawsuit? It's a type of law, depending on the project, that has a bad track in the courts that exposes the taxpayers, all of us here, to substantial legal bills and other ramifications, because this involves constitutional rights out of New Jersey Supreme Court Mount Laurel decision. Last year, on his way out the door, Governor Murphy signed into law the new onerous requirements for towns like ours. Short, this is the fourth round. The law did not pass with bipartisan support. It was driven and adopted by the Democratic majority in the legislature without a single Republican vote. Whatever your politics, that is the reality. Suburban communities like Oakland are being told from the state level to accept a scale and a pace of development that most of our residents and I would never choose in their town. Within the framework, our hands are tied
in important ways. We cannot simply block every higher density or inclusionary project by pointing to traffic, environmental concerns, or older zoning provisions that for years kept multifamily housing out. Traffic, sewer, stormwater, and steep slopes still matter, and they will be scrutinized in engineering and site plan review. But the law will not allow us to use these issues as a blank to excuse or avoid our affordable housing obligations. If we try to do that, the court can and will step in to impose at its will. The stakes of defiance are not abstract. If Oakland is found non-compliant after these statewide deadlines, we risk losing immunity from builders' remedy suits. We risk having a judge rewrite our zoning laws from the bench. We expose the borough to enormous legal costs, including the possibility of being ordered to pay developers, advocacy groups, attorneys' fees on top of our own. That's what the attorney was talking about, fee shifting. Not only we pay for our litigation, we pay for the other side. That would mean your tax dollars funding not just our lawyers, but their lawyers. This past year, me and former councilman attended the mediation process and fought out loud with special judge appointed to implement the law. I even went on to make these, I wanted to make these conversations public, but as advised legally, I cannot. If you recall, sitting with the planner and our attorney, I did make the ask on several occasions to the judge that we wanted to have the recordings of these sessions made public so the public can understand what we're dealing with and how difficult this was to deal with. One of the issues that did come out of one of our hearings was the fact that we did have, I believe, somebody from Fair Share that was removed during the hearings.
The original special adjudicator, yes.
Yes, we had one of the only towns in the state that had somebody removed in these hearings. So when you see this mayor and council advancing rezoning and settlement-based inclusionary projects, it's not because we think Oakland's roads are fine or the flooding is imaginary or that you don't matter. It's because the legal gun is pointed at our head of every suburban town in New Jersey. We're trying to steer through that reality in the least damaging way we can, preserving as much local control as possible rather than surrendering to everything to a judge. You have every right to be angry at how this was done at the state level. You also have a right to expect that given the law we've been handed, your local officials will protect you from even worse outcomes in court. That is what we're trying to do, comply, keep enough to keep Oakland out of the crippling litigation and fee shifting while fighting within the limits of the law, to make sure that any required development is responsible, safe, and consistent with our community's character as possible. We don't ask you to like this law, we ask you to understand and bind it. The bind it puts us is, and it judges us by how we navigate. We ask that you understand the bind that puts us in, and to judge us by how we navigate it on your behalf, not by the false idea that we could simply say no, and it makes it all go away. And that concludes my comments. All right, do we have approval of minutes?
So moved.
February 24th. Well, let me get the minutes up first. February 24th, 2026.
Oops.
Motion approved?
So moved.
Mr. Salian, do I have a second?
Second.
Ms. Rose. Any changes? Not seeing any. Roll call.
Councilman Talamini?
Yes.
Councilman Eilert?
Yes.
Councilman Pignatelli?
Yes.
Councilwoman Rose?
Yes.
Councilman Saliani?
Yes.
February 24th, the executive session minutes.
So moved.
Second.
If anybody have any changes? Not seeing any. Roll call.
Council President Talamini?
Yes.
Councilman Eilert?
Yes.
Councilman Pignatelli?
Yes.
Councilwoman Rose?
Yes.
Councilman Saliani?
Yes.
All right, I kind of went out of order. Do I have a motion to open to public?
So moved.
Do I have a second?
I'll second.
Anybody from the public wish to address the governing body?
Good evening, William Sisti,
Oh, I'm sorry.
12 Eagle Crest Place, Oakland. I'd like to thank the town for all the information they're putting out about what you guys are up against and the state's role and everything else that's going on. What I'm asking, because a lot of people on social media get upset when they kind of find out these developments are happening, it would be wise to get out to the public all the land that there was the 286 units are going to be built on certain pieces of land. Remember, Eric, you went through, and Mr. Mary, you went through and said, no, you can't build houses here because there's rocks underneath these trees. So whatever parcels are left, could that be made public so the public would know that this could be a potential housing site, or this could be, would that be beneficial to keeping the public informed?
Actually, just for our planner, our attorney, once we're done with these ordinances, we're immune for 10 years, correct?
If the court grants us immunity, we're not there yet.
We're not there, but if we get there. Yes.
All right,
So yes,
So would that mean that the land that say to the aerial survey, you said, no, you can't build houses here, but there's a rocks or streams, are those plots of land then not considered anymore? Or will they always still be on the list to consider for development?
Carolyn?
I'm not sure I'm understanding
I
your
think
question.
he's referring to, remember we had the meeting in, I believe it was June, and they had the aerial pictography, and we walked 287 where they wanted to put houses.
Vacant land analysis.
Right,
So
vacant
vacant
land.
No, the
analysis.
VLC,
Yes.
that's
Yeah.
having to do with the obligations, the vacant
Yes.
land? Is that what you're talking about? Maybe
Yes,
that would have been in January?
Yeah.
Is that what you're asking?
I believe, Mr. Sisko?
Yes, that's what I'm asking, yes. Will those vacant land obligations still be valid, even though we don't have to do anything until 2035?
So those, not to make this process more complicated than it already is.
Right.
But what we looked at in January was, were sites that were identified by the state in the calculation of
How many units?
the calculation of our obligation.
Right.
And those are not necessarily properties that would even be eligible for such development. For example, actually, can I say what one of them was? I mean, it's a.
We'll just say any property.
What,
next.
like, for example, there were properties, and I'll take a different town, not Oakland,
All
but
right.
similar thing. There was a house of worship that was, because it had, that was on the list, a portion of the house of worship lot, because there was a small wooded area next to a parking lot. You know, so that was on there. And there was probably similar situations in Oakland. So those aren't even necessarily eligible, those would never be eligible for affordable housing. They were just utilized in the calculation of the obligation to show you the challenges that.
Didn't Oakland do that? They took the aerial and they said, all this is developable, and then we got to appeal that, and then the number for the development went down from 350, and
Yes,
we wanted 250, ended up
your
at
obligation went down.
289, yeah. So are those odd pieces of property that you got to the number of 289 still developable for affordable housing?
What went into the VLC calculation.
Yeah, because a lot of those lots, if I remember correctly.
Those, and also, it doesn't, that was by far not the only factor in what developed what led up to the obligation. I could speak for 3 hours on that whole process as well with the 3 criteria. But that's, I mean, the DCA mapping is public record.
Yeah, it's public record.
It's public
Yeah,
record from the DCA.
Yeah.
If it's still available on their website,
Yeah.
I don't know.
But actually, it's on the video that you guys put together.
Okay.
Yep. I just want to take a minute to thank you, Ms. Pinozzi, and the entire OCC team. I came to you guys very late yesterday and asked you to pull up all the YouTube videos of all 4 hearings so we can post it on the website and Facebook. But thank you so much for being able to cut those up and deliver them so quickly.
Yeah, a couple of staff members were very, they did good work. They did do work. All right, thank you.
Thank you.
That's all for this evening.
Anybody else?
Thank you.
Mr. Schaubeck.
I did, hi.
Name,
So,
please.
sorry, I just spoken already, but my name is Eric Schaubach, E-R-I-K-S-C-H-A-U-B-A-C-H. I live at 61 Loyola Place in Oakland, and I'm president of the Oakland Historical Society. And I've been advocating for historic preservation in Oakland. And I just wanted to reiterate what I said at the meeting, the planning board meeting before, that we have the opportunity to get a grant to do a historic site survey in Oakland. And it would be a 50-50 grant. If the Borough Council authorizes money to be spent on professionals to do a survey of historic sites in Oakland, they could be reimbursed for 50% of that. And the letter of intent would be due at the end of this month, and then the application itself would be April 24th. So let me, let's see, March 27th would be the letter of intent, and April 24th would be the final application. And I'm very happy to assist in the completion of that. And also, I would be a volunteer point person on the ground, trying to inform the professionals on what sites might be historic. And I would avail the resources of the Oakland Historical Society as well. I just wanted to add, because I did ask a question about one of the properties, and apparently something, a site being on the National Register is significant for consideration for affordable housing. Did I understand that correctly?
There's implications.
Implications, okay, fair enough. I think we do have some historic sites that are not on the register that could be, and a survey would reveal that. And the sooner we do it, the better. And I think it's just the right time to do it. So I would appreciate if you considered that carefully. And thank you very much for your hard work on all of this.
Mr. Strobeck?
Yes.
Who's historical liaison?
I am.
Mr. Salian, you want to interface with Mr. Strobeck?
Sure.
And get this thing going?
And can I just ask, do you know how much the survey would cost? Do you have an idea of what it would cost, like in total?
That I don't know, I'm sorry. Yeah.
That was my question for you, how much is it? We have to figure out the cost.
It's a labor-intensive process, right? I mean, Oakland is not a small community geographically, so that means somebody needs to physically survey all the road, right? I mean, all the streets and the entire municipality. That's my limited understanding. I know before COVID, there was someone from the county who would assist with this process, because from another municipality, we'd had these discussions, but it was a much geographically smaller and more compact municipality. But then COVID, you know, I don't know that that's still the case post-COVID.
I think we would need an estimate of what it's going to cost.
Okay.
If you could find out for us and let us know.
I'd be glad to research that for you. And I just wanted to add that I have started tabulating and creating a database myself of my own knowledge, so that might help to some extent. So, and it's all up here.
Thank you, Mr. Strobeck.
Thank you very much.
Anybody else?
Frank Furbacher, 56 Walton Avenue. It's Furbacher. Good evening. Want to thank everyone for all of their time and energy, and really even the last meeting with the planning meeting. You know, the way Chairman Potash was able to make what is a very controversial topic, one that was, I would say that meeting went much shorter than I think it could have gone. So thank you to the planning board and to our professionals who feel like I was in a college lecture that last meeting. The amount that was provided from an educational standpoint was definitely really helpful and impactful for residents, I think. I think there's probably dozens, if not more, residents who weren't attending or weren't watching that meeting, many of which I'm sure continue to have questions. And I do appreciate the borough's notice that went out on Friday, I believe it was, in relation to affordable housing, as well as the video that was compiled by Mr. Sisti and team. Really appreciate it. One of the things, though, that I would just want to say is I do think it would be very helpful for residents to have simple, resident-friendly summaries of what's going on, and in a more proactive way. Something that explains the key points. What is the state requiring? What Oakland's obligation is? And what those next steps are. There's a lot of people who, you know, when it comes to meetings like this, don't necessarily follow up and look at the agendas or look at the minutes. And it is available, but not all residents are going to take that action. And that leads to, I think, what we saw last week and earlier this week, which was rumors flying around, people trying to do their own research, which they should do. But a one-page overview or an FAQ could go a long way toward helping residents stay informed and reducing confusion. It may even be helpful to think about how the borough can provide these kinds of summaries whenever complex issues like this arise. One good thing about all of this is it does create a lot of cohesion and makes it really, truly, not something that's political, but rather something that is more about how do we come together as a community. And I know this is a complicated process, and there are so many towns that are navigating this, but my hope is just simply that as this moves forward, the borough continues to prioritize clear and accessible communication for residents. And just one question, and I don't know how relevant it necessarily is, but when it comes to planning and when it comes to looking at sites or potential sites, does the town have any power, or does it look at even the possibility of acquiring certain properties with the intention of using those sites for future development? Say, for instance, a site is deemed unable to be developed on for whatever reason. Just wondering if the town looks at something like that.
You actually just described Great Oak Park. The town was very proactive in acquiring that piece of property and turning it into a park because it really wasn't developable. And it clearly had a lot of environmental issues, and we took it over and we turned it into a beautiful green space. So this governing body and this town is very actively looking at those opportunities.
Thank you for that. I guess what I'm referring to is more in the sense of the opposite of acquiring a site where the town could say, hey, this might be a good area that's away, we're not going to disrupt a piece of the community as much as, let's say, I think it's the sand pit area.
Unfortunately, these are the two last remaining swaths of land that are really left in Oakland, which is why it was very attractive for the developers and the property owners selling. I mean, this is all about money for them. And these are the last two real big pieces of property.
We bought that property on Breakneck Road.
What's that?
We bought that property on Breakneck Road, too.
Yep.
And just the one thing that I did hear that was interesting was the idea of how do we, if needed, rezone some of the industrial area. I believe that was mentioned in the last meeting. So, that was definitely something I took out of it. But thank you all for your time.
Thank you.
Thank you.
Anybody else? Not seeing anybody? Do you have a motion to close?
So moved.
Do you have a second? All in favor?
Aye.
All right, we're up to resolutions. Okay, that's right. We have to the Oakland Communications Commission for a junior commissioner. I'm putting forward to get Mr. Eric Darcy. And this is with Mayor with council consent.
So moved.
Do you have a second?
Second.
All in favor?
Aye.
Congratulations, Mr. Darcy. All right, we're up to resolutions. I'm going to be removing 26, 19, and 20. The rest we'll do the consent agenda. 26-109, authorized tax refund for overpayment for 107 Grove Street. 26-110, authorized tax refund for overpayment of 24 Chuckanut Drive. 26-111, authorized recreation refunds. 26-112, authorized contract Boswell Engineering for the 2026 road program. 26-113, award contract for Boswell Engineering for Grandview and Acorn Avenue stormwater improvements for construction inspection services. 26-114, amend temporary budget. 26-115, amend budget appropriations. 26-116, authorize LEAP improvement grant application. 26-117, authorize fiscal year 2027 Municipal Alliance grant application. And 26-118, authorize congressional directed spending applications. We're putting in an application for, once again, we got denied last year for continuing the PFOS water treatment out of the Wells Field. And we made application to Senator Kim Booker and our Congressman Poe. Have a motion to
Second.
any discussion on any? Wish to point any out? Not seeing any? Roll call.
Council President Talmini?
Yes.
Councilman Eilert?
Yes.
Councilman Pignatelli?
Yes.
Councilwoman Rose?
Yes.
Councilman Saliani?
Yes.
All right, we're up to 26-119, resolution endorsing the housing element and fair share plan. Would our planner like to take that one?
Thank you. Actually, this is just the planning board adopted it. This is just part of the processes for the governing body to endorse it. Do you want me to talk about the plan again?
I think we're good unless, I think we've heard enough
like to talk
testimony.
about the
like to talk
We're all
about it?
present.
I mean, I will say quite often council members don't even have me come for the endorsement,
Right.
attend the meeting for the endorsement. Of course, I'm here for other reasons.
And while you're at that, 26-120, resolution adopting Fourth Amendment housing spending plan. Or would our attorney like to take that one? No?
No, it's another routine matter that I don't think there really needs much discussion.
Okay. All right, do I have a motion to approve 26-119, resolution endorsing fair housing element and fair share plan, and 26-120, resolution adopting the fourth round affordable housing spending plan?
I'll make the motion.
Mr. Saliani, do I have a second?
Second.
Ms. Rose? Roll call.
Council President Talamini,
Yes.
Councilman Eilert,
Yes.
Councilman Pignatelli,
Yes.
Councilwoman Rose,
Yes.
Councilman Saliani.
Yes.
All right, before we get to the ordinances, we have received numerous emails from residents. I'm going to ask the clerk to please read into the record the correspondences we have received. The people who have sent us correspondence concerning affordable housing.
Thank you, Mayor. On March 9th, 2026, we received correspondence from Jim DePretta from 86 Grove Street, Jami and Nas from 17 Hannah Road, Ursula Becca from 34 Grove Street, and John Lax from 22 Grove Street. On March 10th, we received correspondence from Sandra Sori of 168 Page Drive, Robert Soika of 145 Page Drive. On March 11th, we received correspondence from Stacy McAleer at 15 Whittier Lane and Vincent Furio of 104 Grove Street. And on March 12th, we received correspondence from Alba Vialou of 12 Hannah Road, Rich Ganelli of 111 Page Drive, and Brian Van Grau of 29 Grove Street, all in opposition of Code 26 Code 986, the ordinance.
Thank you. All right, we are up to ordinance adoption. We have 26 Code 983, an ordinance to amend the Borough Code to include a new affordable housing and development fee to conform to state regulations. Do I have a motion open to public?
So moved.
Do I have a second?
Second.
Second? And would anybody from the public like to address 26 Code 983, an ordinance to amend the Borough Code to include new affordable housing and development fee to conform to state regulations? Not seeing any. Do I have a motion to close?
So moved.
Ms. Rose, Mr. Talamini? All in favor?
Aye.
Aye.
All right, who would like to make a motion to adopt 26 Code 983? Mr. Talamini, do you have a second? Who's the second?
Second.
Mr. Saliani? Roll call.
Council President Talamini,
Yes.
Councilman Eilert,
Yes.
Councilman Pignatelli,
Yes.
Councilwoman Rose,
Yes.
Councilman Saliani.
Yes.
All right, we're up to 26 Code 984, an ordinance to amend Section 59-53.1.1 of the Borough Code to revise the permitted density and required affordable housing set aside in the downtown one affordable housing overlay zone. And as everybody here has heard from the testimony from our previous meeting, and also just to be clear, all these ordinance were what do you call it, Tom? And no, not, well, these were right, they were endorsed by the planning board, they were introduced at our last council meeting.
February 24th.
Yep, February 24th. Do I have a motion to open to public?
So moved.
Second.
All in favor?
Aye.
Anybody from the public wish to discuss 26 Code 984? Not seeing anybody, do I have a motion to close?
So moved.
Second.
Second, we got Mr. Eilert and Ms. Rose. All right, who would like to make a motion to 26 Code 984? Motion?
So moved.
Mr. Saliani, do I have a second?
Second.
Mr. Eilert, roll call.
Council President Talamini,
Yes.
Councilman Eilert,
Yes.
Councilman Pignatelli,
Yes.
Councilwoman Rose,
Yes.
Councilman Saliani.
Yes.
All right, 26 Code 985, an ordinance to amend Section 59-53.2.1 of the Borough Code to revise the required affordable set-aside in the downtown 2 affordable housing overlay zone. Do have a motion to open to public?
So moved.
Second.
Ms. Rose, Mr. Talamini, all in favor?
Aye.
Aye.
Would anybody from the public wish to ask questions or address 26 Code 985? Not seeing any public. Do I have a motion to close?
So moved.
Mr. Eilert?
Second.
Who's the second?
Second.
Mr. Saliani? All right, do I have a motion to, I'm sorry, all in favor?
Aye.
Okay. Motion to adopt.
So moved.
Do I have a second?
Second.
Roll call.
Council President Talmini?
Yes.
Councilman Eilert?
Yes.
Councilman Pignatelli?
Yes.
Councilwoman Rose?
Yes.
Councilman Saliani?
Yes.
All right, we're up to 26 Code -986, an ordinance to amend the land use and zoning ordinance to create an affordable housing district for Block 3301, Lot 2, and Block 3401, Lots 11, 12, 19, 40, 43, 52, 53, 57, 58, better known as the McBride property, in connection with the borough's affordable housing obligation. Do I have a motion to open to public?
So moved.
Mr. Tagliamini, Ms. Rose?
Yep.
All in favor?
Aye.
Anybody from the public wish to discuss 26 Code 986? This is the McBride property. Not seeing anybody. Do I have a motion to close?
So moved.
Mr. Saliani, do I have a second?
Second.
Mr. Eiler? Who would like to make a motion to adopt 20? All in favor?
Excuse me, Mr. Mayor?
Yeah.
Sorry, I'm sorry, go ahead.
Mayor, my understanding was that the planning board found that to be partially inconsistent with the master plan.
Okay.
So in order to adopt it, the mayor and council, number one, has to pass it by a supermajority, but number two, needs to put reasons on the record as to why they're adopting an ordinance that's not consistent with the master plan, which obviously is to comply with our affordable housing obligation.
Okay. Does anybody have any questions? Good?
Okay, yes.
Okay. Now I can do, who would like to motion to adopt?
One where we need a supermajority. I said, I'm doing this one.
Motion to adopt?
Motion to adopt.
Mr. Talamini? Do you have a second?
Based on what he said.
I'll second.
Mr. Saliani? Okay.
Mandate.
Roll call.
Hang on one second here. Just make a couple notes. All right, roll call.
Councilman Talmini?
Yes.
Councilman Eilert?
Yes.
Councilman Pignatelli?
Mm,
Is it a yes?
I don't know. That's a tough
We need a supermajority.
one. Okay, yes.
Councilwoman Rose?
Yes.
Councilman Saliani?
Yes.
All right, we're up to our last ordinance, 26 Code 987, an ordinance to create a new exclusionary zone district for 129 McCoy Road, Block 4004, Lots 4 and 5, better known as Leone property in the Borough of Oakland, Bergen County, New Jersey. Counselor, do we have?
Mayor, this is the same as the one you just considered. It is not in compliance with the land use element of the master plan. So I think that you need to note that the board found it to be inconsistent with a portion of the master plan, but you're adopting it in order to comply with your affordable housing obligation.
So does this have to be supermajority also?
Yes.
Yes.
Does anybody have any questions? Not seeing any. Do I have a motion to open to public, 26 Code 987?
So moved.
Second open.
I got Mr. Talamini, Mr. Saliani, all in favor?
Aye.
Anybody from the public wish to address 26 Code 987? Not seeing anybody. Do I have a motion to close?
So moved.
Second.
Mr. Eilert, Mr. Saliani. All right, do I have a motion? All, well,
Aye.
okay. Do I have a motion to adopt?
So moved, based on the recommendations of our attorney, Mr. Giblin.
Mr. Talamini, do I have a second?
Second.
Mr. Eilert? Roll call.
Council President Talmini?
Yes.
Councilman Eilert?
Yes.
Councilman Pignatelli?
Yes.
Councilwoman Rose?
Yes.
Councilman Saliani?
Yes.
All right, that concludes our ordinances. We're up to, we don't have a work session. Does anybody have any new business to bring forward?
Yeah, a couple of things, and it's a little bit new business / reports. First of all, I want to thank the professionals for their time tonight. You actually made it a little easy on us, to be honest. You answered a lot of the questions at the planning board, but I really want to thank you for your explanations over the last couple of weeks and helping us communicate with the public. So I want to make sure that was called out appropriately. Additionally, I know we weren't going to do committee reports tonight. I do want to speak about that. There was there was an election on Tuesday, and I do want to thank former Councilman Zelinski We worked with him. I think he did a very good job. So we want to thank him for his running, and I do want to extend my congratulations to new councilman-elect. And, we just move forward from here. But I just think we should acknowledge that it's very tough to do these things and run, and with all the chatter back and forth that was out there, I hope that's all noise and we just move forward in a positive manner.
Thank you, sir. Anybody else have any new business? Anybody have any old business? We're going to dispense with committee liaison reports. Can we go right to bills to be paid?
Yes, bills to be paid is $366,109.27. So moved.
Do we have a second?
Second.
Any discussion? Not seeing any, roll call.
Council President Talamini?
Yes.
Councilman Eilert?
Yes.
Councilman Pignatelli?
Yes.
Councilwoman Rose?
Yes.
Councilman Saliani?
Yes.
All right, we paid the bills. Also, I just want to extend a congratulations to Mr. Dumper. He's sitting right over there. Congratulations on winning the election. We look forward to working with you and going forward. At this point, we're up to adjournment. The next Borough Council meeting will be held on Tuesday, March 24th, 2026 at 7 p.m. here at the Council Chambers. Unfortunately, I will not be here. I will be on vacation, but will be in Mr. Talamini's capable hands.
Before we close, the chief did ask me to say one thing, even though we weren't doing updates. The police will be doing DWI patrols on St. Patrick's Day. I think it's a very important reminder to the community that just pick an Uber on St. Patrick's Day.
Okay. Do I have a motion to adjourn?
So moved.
We got it. Mr. Saliani, Mr. Talamini on the second. All in favor?
Aye.
All right, this concludes today's meeting. Thank you, everybody.